May I please, your lordship? May I please, your lordship?
Yes.
I beg to mention the new case, lordship, in motion.
Motion.
Yes, lordship.
Monday.
In Wednesday, lordship.
Hmm?
Wednesday, lordship.
Why are you mentioning it now? When did you file it?
Tomorrow. Yes, yesterday. lordship.
Yesterday. So it will come on its own. Don't mention it. Not necessary.
Fine.
Not necessary to mention for Wednesday.
Can it be tomorrow, lordship?
Either you have it on Monday or you wait till Wednesday to see if your matters are listed. If not, you make a mention on Wednesday.
Monday, lordship. Monday.
Yes.
I'm praying for a listing of a family pension matter for admission next week, madam.
Next weeks have all been declared to be motion days.
Motion day, madam. Yes. Anyway,
can-
Monday, Tuesday.
We can give you a date in January, immediately
But
after.
family pension. She has been drawing family pension, but that doesn't stop, madam.
When was it stopped?
A month back. A month back. A month back.
Well, let us have it tomorrow.
Yes. Yes.
May I please, Your Lordship, with regard to item number 53, my lord.
53.
So Lordship,
Yes.
recollection, my lordship was hearing the matter, Lordship had sought for certain instructions, my lord, regarding that reduction from the pensionary benefits. The instructions are
FR 22.
FR 22. I have not received the instructions as yet.
Whether it was initial direct recruitment or
That
motion.
post one
That
post-
instruction he was supposed to take, Lordship. Otherwise,
So can we make an attempt next week?
Not next week. It has to be in January.
yes.
In the first week of
Pardon?
January then,
8th of January?
8th of January.
This is a hearing matter.
This is a hearing.
Hearing matter.
We can have it
It has been
on,
hearing.
yes, 8th of January.
I'm
Item 53, on a request made by Mr. N. Deka, Standing Counsel APDCL, matter stands referred to be listed on 8th of January. Mr. Dr. G.J. Sarma, counsel for the petitioner, is also present. Yes.
If it is lordship, I have filed a IA in a case for correction of a date in the order. Although it's a little bit older order, but that is only a correction.
Monday.
May I please, your lordship? Lordship, I beg to mention for listing of a contempt case, lordship, in order, lordship. On
Contempt case for motion, admission,
order,
order,
lordship, order, lordship.
order.
The last listed on February, lordship.
So why were you not
On Monday.
pursuing the matter? Since so many months, if it was last listed
Yes,
on
lordship,
February,
it's for the last,
order has been complied with.
no, lordship.
Then it wait, let it come in January. List on 28th of January.
28.
Sorry, 19th of January.
I'm a place, lordship.
Yes.
May it please, your lordship, listing for motion, your lordship.
When was it filed?
Yesterday, your lordship.
It will come by Monday, Tuesday, Wednesday.
So can it be on Wednesday or Monday, your lordship?
No, but why you want an out of turn mention?
Lordship, actually, I have some difficulties on 18th and 19th, your lordship.
You see if it is listed on Monday. If not, you make a mention.
So kindly on Wednesday, your lordship.
All right, Wednesday.
Oblige, your lordship.
May it please, your lordship. Lordship, I beg to mention for adjournment of item number 3.
Item
Item 3.
3.
Yes, lord.
Why?
Lordship, my senior is out of station, lordship.
What about the respondents?
I have taken consent of respondents also, lordship.
No objection.
No objection. All right, item 3 passed over.
Lordship,
the day.
interim may be continued, lordship.
Then don't make a mention. Wait for the matter to be called up. Why you making a mention and ask extension of interim order? We will not extend interim order. Will not extend.
Okay, lordship, I'll wait for the
You wait for the matter to be called up.
obliged, lordship.
Yes.
May it please, your lordship, in regard to the item number 50, a prior adjournment slip was circulated yesterday, lordship.
15 is a part of the series.
50, 50, 50, the arbitration petition.
50.
Yes. Yesterday, we have already given the adjournment slip, lordship, with the consent of the
They have
others.
agreed. Petitioners have
They have
agreed.
agreed.
All right.
And we have also agreed for a date, lordship, in the month of January on 8th of.
Joint request matter stands deferred to be listed
On 8th of January.
not 8th. On 30th January,
3-0, Lordship.
30.
Deeply obliged.
Supplementary date for result, item 55.
On the submissions of the counsel for the petitioner on instructions, received on instruction. The petition stands dismissed on withdrawal. Interim orders, if any, stands vacated. Why are you withdrawing this matter?
Not to press my, not to press my, right, the instruction petitioner is not willing to
The
press.
petition, submission, the counsel for the petitioner on instruction submits that petitioner has instructed him not to press the petition any further. Finally, the same stands dismissed on withdrawal. Interim orders, if any, stand vacated, pending ayes are also dismissed.
56. Item number 56, my lord, petitioner has got the relief, my lord, so matter has become.
It is submitted on instructions by the counsel for the petitioner that the grievance of the petitioner has been redressed by the respondents. Therefore, he does not wish to press the petition any further. Accordingly, writ petition stands dismissed. Has not pressed. Interim orders, if any, stands vacated. Pending ayes are also dismissed.
Much of lordship.
Daily list for motion item 1.
May I please, your lordship. Lordship, this matter had come up on the 31st of October. This relates to that cancellation of my candidature by IOCL. My lords, a query had fallen from your lordships with respect to UGC, your lordships. Why we have not implemented UGC. My lords, may kindly on that
There was
aspect.
some degree not recognized, some diploma.
Yes, that's correct, my lords. Postgraduate diploma in global business operation is what I had done. And my lords, the advertisement issued by IOCL, which is at page 35, annexure P1, clause 1.1.1, my lords, if I may read, the educational qualification which was mandated in the advertisement stated at 1.1.1 that it should be a 2-year full-time regular course leading to postgraduate diploma, master's degree in business administration, or equivalent with specialization in marketing management, or an equivalent qualification from a recognized Indian university. Now, my lord, my case is not that I am claiming that my degree is equivalent to MBA marketing. But what I claim is that the course that I have done, it falls within the purview of clause 1.1.1 of the advertisement, my lords.
What is that course you have done?
My lords, postgraduate diploma in global business operation, which your lordship should find. I have annexed the degree at page 43, your lordships.
That is it sufficient to make you eligible for marketing management?
I'll satisfy your lordships. How? Your lordships, I have got specialized subjects in marketing. Now, my lords, to that extent, my submission is that insisting on solely the degree title without considering the actual curriculum would amount to elevating the form over substance. So the clause has to be given a purposive interpretation. If my lords kindly has page 35 once again for a moment.
Yes.
My lords, 1.1.1 clearly says that I must have a 2-year full-time regular course leading to PGDM or master's degree in business administration, which is MBA, or equivalent with specialization in marketing management, or an equivalent qualification from a recognized Indian university. So, my lords, the course that I did does have specialized subjects in marketing, which has also been confirmed by the college. When IOCL writes to them regarding the equivalence issue, they write back saying that it is not equivalent to MBA. However, it has specialized subjects in marketing. So, my lords, my contention is that when I have specialized subjects in marketing and when the clause of the advertisement provides that leeway, it ought to be given a purposive interpretation, my lords. To that extent, if your lordships will permit, I would like to show a judgment of the Supreme Court, your lordships. Although
Let
that
us-
judgment,
Let us understand the
Yes.
facts first before you take us.
I
to
apologize, your
Supreme Court.
lordships.
Because who is the authority to decide?
To that extent also, your lordships, in the advertisement itself at clause 1.4,
Where is that communication from the college?
I'll just show. Lordships may have page 56, your lordships, which is a typed copy, annexure 9.
56. Yes.
This is the letter which SRCC writes to the respondent, stating at para 1 that postgraduate diploma in global business operation program is not equivalent to MBA marketing, but its course curriculum has specialized subjects in marketing. And point 2, it says regarding its recognition by UGC, it is a course of University of Delhi with a ordinance number so and so since 1999. Now, my lords, these clarifications had come, post which my candidature came to be rejected on the 10th of January 2019. I approached this honorable court by filing a writ petition, whereby on the first day, the court was pleased to keep that post vacant till the pendency of the writ petition. Thereafter, while disposing of the writ petition, this honorable court was pleased to direct me to file a fresh representation before the respondent with all necessary documents which had to be considered in accordance with law and pass a reasoned order. Our grievance, my lords, is that once we gave that representation pursuant to the judgment of this honorable court on the 1st of April 25, the rejection, the earlier rejection was reiterated, my lords, without considering the documents which I had placed.
Have they written to the UGC or AICTE? Is it under UGC or AICTE?
My lords, it is under none. In my respectful view, I will show from the notification itself, from the advertisement itself.
No. Is your degree recognized or required to be recognized under UGC or AICTE?
Not under AICTE, your lordships. It is, I showed page 56 where it says regarding its recognition by UGC, it is a course of University of Delhi with a ordinance number so and so. The question of recognition does not arise, my lords. It is a degree which is recognized because SRCC itself has clarified that. And in fact, if your lordships has the notification of IOCL at clause 1.4, I showed page 35, 1.1.1. If your lordships has 1.4, they themselves say that candidates having,
Yes.
page 35, your lordships has it. 1.4, your lordships. Candidates having postgraduate diploma certificate awarded by Indian University, Institute of Foreign Degree, diploma certificate awarded by foreign university or institute should in their own interest ascertain the equivalence of their diploma degree certificate with master's degree recognized by Indian universities from Association of Indian Universities. Which is the reason that IOCL wrote to AIU. AIU said you write to the college. That is how the college then came back and
what
gave.
is AIU?
Association of Indian Universities, my lords, this is a society under the Societies Registration Act. Now the issue is that, my lords, AIU does not give equivalence to universities, it gives it to standalone universities, which also AIU has
This is a degree for how many years or months?
my lords, it was a 2-year full-time course which I had
2-year
pursued. Yes.
Yes, Mr. Chaudhary, what do you say?
My lord, the SRCC itself says, my lord, it is not equivalent.
Where is that?
That your lordship has just seen, my lord.
56.
Is
56.
page 56, my lord. And this issue was, my lord, considered in the earlier writ petition. I'll draw your lordship attention to, my lord, certain observation in the earlier writ petition. This, my lord, page 56 itself, my lord, says that a postgraduate in diploma in global business
It's not
operations.
equivalent, but has specialized subject in marketing.
Yes, it has only a specialized subject, my
This is
lord.
what your advertisement says.
My lord, if your lordship kindly comes to the earlier order, my lord, order passed in the earlier writ petition, page 89.
89.
Page 89 at paragraph 10. there, my lord, it is said that the question of equivalence of a particular diploma degree with another lies in the domain of experts, which in a case like this would be the authorities such as UGC, AICTE, etc. However, the writ petitioner has not implicated any of those authorities in the writ petition. Under the circumstances, considering the materials available on record, it is not possible for this court to give any decision on the question of equivalence of postgraduate diploma obtained by the petitioner with other PGDM as per the advertised notice. Then your lordship will also, my lord, read paragraph 12 and 13. At the same time, after a lapse of more than 5 years since the advertisement was issued, it is not clear as to whether the petitioner would at all be interested to join. Then paragraph 13, my lord, however, the petitioner is granted liberty to produce relevant documentary evidence before the authorities in the form of a representation establishing that the postgraduate diploma in global business operations program undergone by him is equivalent to postgraduate diploma in marketing management offered by any recognized university institutions in India. My lord, pursuant to this, he had filed a representation, my lord, but no new document has been, my lord, produced.
Yeah,
And
what is the stage of the recruitment process?
My lord, that process is already over. My lord, one post was kept vacant. Now that has not been filled up yet. But the question here is, my lord, when the fresh documents could be placed, my lord, the IOCL doesn't have any other option but to reject his my lord, representation. And my lord, UGC and 80 not having been made party, my lord, IOC is not the authority, my lord, who can determine it doesn't have the expertise, my lord, to say whether it is equivalent or not. And the college itself says, my lord, it is not equivalent.
So what is the qualification required is MBA?
Qualification required in MBA.
No, what is educational qualification that you are asking is what?
That is at, my lord, 1.1 at
So
page
35.
PG
35.
diploma, masters.
Page 35. We had written to the, my lord, that has been discussed in the earlier judgment. We had, my lord, written to the respondent number 3. Then, my lord, the respondent number 3 says that you approach the college, and college says it is not equivalent. Whether, my lord, the particular
No, it only says it is not equivalent to MBA.
my lord.
Your requirement is not MBA. Your requirement is PG diploma in master's degree
Yes, my lord. That's why, my
or
lord,
master's degree in business administration.
the appropriate authority would be, my lord, either the, my lord, UGC or the, my lord, AICTE, and those are not also parties in the present writ petition, in spite of the observation made by this honorable
Yes,
court.
Mr. Counsel.
Well, in my respectful view, page 35, which your lordships has seen,
Hmm.
clause 1.1.1 we've read out to you. Clause 1.3 is also quite important, your lordships, if I may permit you to read that. It says, in the absence of the above, Indian Oil shall be at liberty to decide the specialization based on the courses opted by the candidate during their post-graduation study of the qualifying course. The candidates must have majority of the elective papers from marketing management. Now, your lordships, the learned senior counsel had pointed out that post the judgment of this honorable court, I approached IOCL with a fresh representation. However, I did not bring any new document on record. Because I would like to differ.
What order was passed by the IOC? With rejecting your representation?
Yes.
Yes,
Where is-
reject.
That is,
That is at page 97, your lordships, the typed copy, annexure 19. May I read your lordship?
Yes.
It says, Dear Mr. Datta, this is reference to your representation dated 7/4/2025, consequent to the order dated so-and-so of the Guwahati High Court in writ petition so-and-so, wherein the Honorable High Court has granted your liberty to produce relevant documentary evidence before the authorities in the form of a representation establishing that the postgraduate diploma in global business operation program is equivalent to postgraduate diploma in marketing management offered by any recognized university institute in India. After examination of the representation, it is observed that you have not brought out any evidence or proof regarding equivalency to postgraduate diploma in GBO from SRCC to MBA marketing or postgraduate diploma specializing in marketing management. In view of the above, your representation cannot be considered. An order with reference number so and so dated 10/1/2019, which was the original cancellation regarding cancellation of your candidature continues to stand.
No, but the college authorities have stated it is not equivalent to MBA.
That's correct, Your Lordship. They've stated it's not equivalent to MBA, but they say I have specialized subjects in marketing. Now, if I go back to clause 1.1.1,
Yes.
1.1.1 gives a leeway to say it has to be a 2-year full-time course leading to an MBA marketing or equivalent with specialization in marketing.
That's right. So specialization marketing is to be qualified by equivalence. It has to be equivalent first with MBA,
Well,
and have specialized marketing.
May I show another document, my lords, which
Yes.
SRCC has itself given to us.
Yes.
If your lordships kindly has page number 59, your lordships, annexure 11.
Yes.
Now, this is a certification given by SRCC to the petitioner, where it says this is to certify that so-and-so, son of so-and-so, roll number so-and-so, batch so-and-so, has successfully passed the 2-year full-time postgraduate program titled PG Diploma in GBO offered by SRCC, a constituent college of the University of Delhi. The University of Delhi awards a unique PG Diploma in GBO on successful completion of the course. The second paragraph is important, your lordships. It says, the PG Diploma in GBO program is spread over 4 semesters of the coursework besides summer internship. The core subjects in marketing are principles of marketing, cross-cultural buying behavior, transnational marketing, social and ethical issues in business includes a chapter on ethics and marketing. This certificate is issued on the request of the student.
This was not placed before the authorities.
But this along with all other subsequent documents were placed in the fresh representation before IOCL.
Issue notice, you file your objections or whatever you want to file.
My lord, in effect, my lord, the petitioner is placing the same case which was placed
Whatever
earlier.
it is, you bring it on record. Use it. Third counsel for parties issue notice written in about 4 weeks, Mr. M. Sharma.
I appeal for respondent
Counsel
1 and 2.
appears and accepts notice on behalf of respondents 1 and 2. Therefore, notices are waived, extra copies be furnished within a period of 1 week from today. Steps on respondent 3 by registered post. List after returnable date.
Bless.
Obliged.
For admission, item E.
Income tax or item. Yes.
On the last occasion, I placed before lordship the facts of the case, the section 148 notice which was issued. On the ground that the,
Can you recapitulate just for refreshing the memory?
my lord. My lord, the 148 notice which was there, the reasons to recorded was mainly on the ground that certain amount was received by the petitioner. The petitioner objected to the reasons recorded that no amount was received by the petitioner. In fact, the amount was paid to the firm concerned for purchase of the goods. Now, the petitioner enclosed all the documents and papers to show that the goods were purchased, including the invoices, the bad payment, everything, tax invoice. And subsequently, the authority has said that these purchases were bogus and there was no purchases made, and thereby again added the same to the income of the assets. Now, the point which was raised before lordship was that, that the reasons to be recorded which was there, that was on the ground that the amount was received by the petitioner. Now, if the reasons was on the ground that the amount was received by the petitioner, subsequently, the authority cannot take the view that the amount was paid But the amount which was paid was bogus purchases and no purchases were made by the petitioner. But it is settled law that the reasons to recorded cannot be changed and nothing can be added and nothing can be reduced. It has to be strictly on the basis of the regions recorded. Well, I annexed all the papers and documents to show that the purchases were made, including the payment which was made, tax payment which was made by the supplier, and all the e-way bill, etc. Everything has been annexed. The only thing which the lawsuit has to examine is that whether the authority has the power to go beyond the regions recorded and proceed to justify the section 148 of the Income Tax Act.
Yes.
On that, my lord, on the last occasion, I was to place before your lordship the relevant judgments.
You're referring to page 77, the reasons,
My lord,
para number 4,
my lord,
that it was first identified to be credits credited to your account.
my lord.
And then subsequently,
Subsequently, it has been said, my lord, when I submitted a presentation reply, the order you'll also find the so cause you'll also find at page 172. Page 174. Para 5. In the above context, it is important to analyze the bank accounts and the balances of the paper company, namely so and so. There are bogus credits into the bank accounts of the paper company. Now it says, the credits were in the paper company. So and so, out of these credits, amounts of rupees so and so were transferred from the SSC to so and so. The detailed analysis of the investigation wing of the department in respect of the so and so private limited revealed that there was no actual business transactions. Involvement of the goods happened with the so and so limited by the SSC, but only the transfer of the amount took place. Now here, my lord, the view which has been taken is that the amount which was transferred credited in that company, my lord, and there were no actual business transactions that had taken place.
yes,
Thereafter, your lordship may see page 175. This notice was issued, my lord, on 29/3/2022 at page 172, you'll also find.
yes,
And you'll also find at page 175, 3. Kindly submit your response through the registered e-filing account of the so-and-so by 30/3/2022.
sorry,
Well, you'll also find at serial number 3. Kindly submit your
serial number 3 of page
page 175.
175, yes,
Kindly submit your response through the registered e-filing account of so-and-so by 23:59 hours on 30/3/2022.
1 day.
1 day. And thereafter, my lord, since it is not possible for.
Because it becomes time barred.
My lord,
Because it will become time barred after that.
whatever may happen, my lord, I will go on the merits mainly, my lord.
Yes, yes.
And also, your lordship directed me to prepare a short note also.
Yeah, you're not filing affidavits.
No, Lordship, I have with me original record with me.
Huh?
This Lordship, it was submitted that no affidavit will be filed. I have obtained the original records, Lordship.
So original records for what purpose?
To assist your Lordship by these things.
We are examining the reasons vis-a-vis the show cause notice and the assessment order passed.
Lordship.
It is not the case projected before this court that these were not issued properly or without following the procedure prescribed. The case projected here is that you had given reasons stating one thing, and in the show cause you have made a complete volte-face. That's the only thing. So, do the records show something else?
Reasoning, Lordship, for why these things happen, that is available in the record.
So whatever it may be, you have given the reasons.
Lordship, by Tuesday, I will complete.
Huh?
By Tuesday, because everything is ready. Lordship, directly I will file my. No, on the last occasion you have said. Yes, Lordship, I have submitted. I'm not. You recorded that no affidavit will be filed. Yes. I'm replying to the court's query. It's all right. The last order, my Lordship. Yes, Lordship, it is my submission. Don't shout. What I am submitting, I am saying. It is my submission, Lordship. Only it was recorded. In the order. That cannot be changed. I'm not changing my stand. Para 7 of the last order, which was last passed. Yes. It is there, Lord.
Yes. All right. Do you want to file or you don't want to file?
Lordship, direct me, Lordship, by Tuesday.
We are not direct. Why should we direct you? We have already issued notice. We have recorded that you don't wish to file.
Yes, Lordship. On last occasion, I submitted. That,
so you maintain that stand, or you want to revisit your?
Lordship, by Tuesday, then I'll come with the explanation.
It's like the reasons you have furnished.
No, Lordship, by Tuesday, I'll file, Lordship.
All right, let us hear. You file it. See.
Oh, Lordship, I will take your Lordship to the first judgment which I am placing at page 41.
Yes, it would be okay. You want to file it by Tuesday?
Lordship.
I think
I cannot.
We'll give him an opportunity to file it because we'll be closing the matter.
I will not object that he should not file. He should have always filed, Milord. He himself said I will not file. That's why I'm submitting.
Yes, we recorded.
If he wants to file it, on Lordship, last occasion, what happened, Lordship, original record was not with me. I didn't receive any communication from the department. Lordship, after that, Lordship, I communicated, they sent the original record along with the progress comments.
Very well, then you file it.
Lordship, it's better they file it, Milord.
We had asked you. You said you don't want to file it.
No, on last occasion, Lordship, I submitted that.
That's okay, but you would have mentioned it in the morning to say that you have received the records, you're proceeding to file it.
By Tuesday,
all right, heard. So then we will have to go to January.
No, if Tuesday is files it will be heard. I will not file reply.
Tuesday.
What reply is there? Because whatever is there in the orders, they cannot change the orders by way of affidavit.
Heard counsel for parties. Dr. Saraf for the petitioner, assisted by Mr. N.N. Datta. And Mr. S.C. Kyal, standing counsel income tax, assisted by Mr. K. Jain. Mr. Kyal, although submits that although on the last date, since the records were not received by him, he submitted that matter can be heard without filing an affidavit on behalf of the respondents. Kumar today submits that the records have been received recently. Original records of the department have been received recently. Therefore, he proposes to file an affidavit by next week. As agreed to by the counsel for the parties, list again on Tuesday. Tuesday?
I file my affidavit by Tuesday. What's it by on Wednesday maybe list? Wednesday will be motion day, my lord.
All week,
All
all week is
weeks is a-
Sunday.
Well, lordship will just take the trouble because he's filing the affidavit at page 47, my lord.
Let the matter be listed on Wednesday. 47,
Of the paper, my lord.
yes.
It starts with page 41.
Hmm?
It starts with page 41, page 47, my lord.
Yes.
It is needless to mention, as your lordship put in. First line.
Which placitum? A. Yes.
It is needless to mention that the regions are required to be read as they were recorded by the assessing officer. No substitution or deletion is permissible. No addition can be made to those regions. No inference can be allowed to be drawn based on the regions not recorded. It is for the assessing officer to disclose and open his mind to regions recorded. He has to speak through the regions. It is for the assessing officer to reach the conclusion as to whether there was failure on the part of the assessee to disclose fully material facts necessary for the assessment or the concerned assessment here. It is for the assessing officer to form his opinion. It is for him to put his opinion and report in black and white. The regions recorded should be clear and unambiguous and should not suffer from any vagueness. The regions recorded must disclose his mind. The regions are manifestation of the mind of the assessing officer. The regions recorded should be self-explanatory and should not keep the assessee guessing for the regions. Regions provide the link between the conclusion and the evidence. The regions recorded must be based on the evidence. The assessing officer in the event of challenge to the regions must be able to justify the same based on the materials available in record. He must disclose in the regions as to what, in fact, which fact or material was not disclosed by the assessee fully or truly for the assessment or the assessment here, so as to establish the vital link between the regions and the evidence. That vital link is the safeguard against the arbitrary reopening of the concluded assessment. The regions recorded by the assessing officer cannot be supplemented by way of filing an affidavit or making an oral admission. Otherwise, the regions which were lacking in the material particles would get supplemented by the time the matter reaches the court.
Yes.
So, the regions recorded were there that I have received the amount
Credited.
credit in my account. Now, by way of an affidavit or by anything, it cannot be justified that the amount was not credited in somebody else's account.
All right. Wednesday.
Not
It's again on Wednesday.
next to the.
Lordship,
Yes.
Lordship, this
Readings are ready.
Lordship,
Affidavit not filed.
no.
We have received necessary communication. If my learned friend argues, then I can place my account. Without filing.
They're seeking time.
We fix in the month of January.
On a prayer made by the counsel for the petitioner that the arguing counsel is out of station. Matter stands deferred. Is agreed to by both parties with this matter again on 6th of January.
Not.
Interim order passed, it will continue till the next date fixed.
Obliged, Lordship.
All.
Lordship, I prefer some time to file the affidavit. It will be filed before the vacation, my lord, I assure. Any day, my lord, after the BU, my lord.
In fact, the issue.
Where you file it, we'll ensure that you file it. We'll have it on Wednesday.
No, my lord, let it be after the vacation, please. Some
In
time.
fact, the issue is fully covered by the judgment of the Honorable Court. In fact,
What is
also-
the issue here?
Well, the issue was that, my lord, the raw petroleum coke was converted in the crystal petroleum coke And both raw petroleum coke and consolidated petroleum coke fall within the purview of the coke in oil form. And in the very beginning, 1971, the India Carbons case onwards, it was held that these are declared goods. As per section 15B of the Central Sales Tax Act, when the raw petroleum coke is declared goods is purchased within the state by the payment of tax, and the same are sold in course of interstate trade and commerce, and the tax is paid thereon, then the local tax has to be refunded, reimbursed to the person concerned making the sale. Now, my lord, this issue came up earlier also, before this honorable court, again before the apex court also, my lord. And the apex court held that when the raw petroleum coke is converted in the calcined petroleum coke and is sold in course of interstate trade and commerce, and tax is paid thereon under the CST Act, that local tax has to be reimbursed. Thereafter, again, my lord, the matter again come up before dispute was there. The matter came up before this honorable court again, and the matter was carried again before the apex court. And ultimately, it was held, my lord, that the refunds will have to be granted. And to those persons, industry needs, the refunds were granted. Now, the similar circumstances here, the refunds applications were filed, and the refund applications have been rejected on few of the grounds. Now, one of the grounds is that, my lord, the petitioner was not a party to the proceedings before the apex court. Secondly, my lord, that the assessment which was completed by the assessing officer was without jurisdiction. Third, that, my lord, the petitioner has treated the calcined petroleum and raw petroleum coke a different commercial commodity for the purpose of the remission, and thereby the same cannot be said to be a declared goods, same declared goods. And that the CST was paid at the rate of 1% because of the remission, and thereby the full central sales tax was not paid. All the issues have been examined by the single judge in this judgment, my lord, and the issue has been decided in favor of the SSC.
Are you saying it is covered by the Brahmaputra?
No, my lord, this is carbon resources. Recently, the
Carbon.
judgment has come, my lord.
Yes. This has not been carried to appeal.
No.
Attained finality. The judgment has attained finality.
I will have to examine that. But let me file my short affidavit, madam. Because they have given a detailed affidavit. Para-wise follow.
But no appeal has been preferred will be, my lord, because in one of the cases after the judgment, they've examined it and again rejected it. That means, my lord, the state has not filed, is not interested in filing the
All
fee.
right, heard Dr. Saraf, still by Mr. N.N. Proctor. For the petitioner, also heard Mr. B.B. Gogoi, learned additionally appearing for the state. Mr. Gogoi submits that you'd like to file an affidavit in this regard. So Mr. Dr. Saraf on the other end submits that these matters have been decided by a coordinate bench, and therefore it stands covered by the judgment and order rendered by the coordinate bench. So, be it as it may, since the respondents crave leave to file their affidavit, we permit 2 weeks.
Well, 2 weeks.
2 weeks further time to file the affidavit, by which time it is expected that the affidavit sought to be filed with the respondents should be filed based on on 8th January. 8th of January.
Yeah, 8 already 2-3 matters of 6. My lord, can it be 6th or my lord 20th?
All right, 20 January.
20.
20 January.
Obliged. me.
Item 5.
I beg to apologize, Your Lordship. Instruction has been received. I want it time to be granted, Your Lordship. I will file my affidavit. Affidavit in ready.
Matter about? What is the matter about?
In this case, we are challenging the impugned order dated 29/2022, whereby the rejection of the exemption claim was, rejected by the respondent number 2 Laksh.
Page 84, Your Lordship. Why it has been rejected, it has been there in Annexure 6, your lordship. They have not filed their relevant documents. And they condoned for a 365 days for 283 days for filing of form number 10B, your lordship.
It's been 1 year, there's an interim order passed. Why have you not filed your affidavit?
Lordship, that is the, I've done mistake.
We'll confirm this interim order and allow the writ petition.
No, lordship,
So 1 year you have allowed the interim order to extend.
lordship, but Wednesday I will file, your lordship. It has been ready.
The
your lordship.
matter, the last, you were given time on 9/12 to file an affidavit.
I beg to apologize, lordship. That is my, I have picked my responsibility. Lordship.
You pay cost. You pay cost.
Lordship, I beg to apologize. Lordship. Wednesday I will file because instruction have been, we have reminders, but no instruction now.
Don't file it if instructions have not come. You argue on the legal issues.
I will take care. Lordship. This is the, I undertake myself.
You file it by Wednesday.
Lordship.
List on Wednesday. The permitting the standing council income tax to file their affidavits as it is submitted that the affidavit, the instructions have been received. Yes,
So interim may kindly be continued.
interim order passed early will continue till the next date.
Obliged.
I am deeply obliged.
6.
My pleasure, Lordship. Lordship, the matter pertains to the appointment of sole arbitrator, section 11(6) of the Arbitration Act, Lordship.
Lordship, in this case, H. Gupta is appearing, Lordship, he is out of session today. So it may be taken up any other date, Lordship.
Passed over. Matter stands passed over on the request made by MSR Devi on behalf of Mr. H. Gupta. This next week.
Lordship, if may I pray for a date, your Lordship, because Lordship. they have-
Monday.
Huh?
Monday.
Deeply obliged.
Obliged.
Monday, 15th.
Deeply obliged.
Yes.
Item 7.
Wait, please, your lordship, kindly possible for timing, lordship, he's on late, court number 8. We have already received the instruction, lordship. Senior has,
What instructions were sought for?
actually, Bharveli received the instruction. I am not aware, lordship.
Some register regarding attendance register.
Hmm?
Attendance register was supposed to be produced today.
All right, time being, call him.
8 is same, lordship. 8 is
No,
same.
you inform him we are passing it over for the time being. We are not adjourning it.
Yes, lordship.
8 is different matter.
It is different matter. Kindly pass on for timing. Both.
You have not even called item number 8. Any other matters you want to be adjourned from the list? Tell us.
Item 8.
Who's for the petitioner? Some mediation report is there.
Actually, lordship, due to non-representation of finance department, lordship, the matter could not be settled, lordship. Otherwise, it was a settleable matter, lordship. And so far, my information, lordship, there are certain development. And there is an order, lordship, specific order on 27 March 2025, lordship, court's order, lordship.
Nice.
Complying that order, lordship, steps were taken by the council and the Hill Area Department, lordship, and the proposal is pending before the finance department, lordship.
Who's for finance? Financial sanction is not approved.
Lordship,
Mr. Dhor appears in this matter.
Yes, lordship, for PWD.
Ah,
Thank you.
And Madam Chakrabarti is appearing for
It's for number 4 NC.
NC Hills. This is a case of release of area salaries. So what has happened? NC Hills is supposed to release it.
A proposal was sent to the finance department, madam. A matter perhaps is pending, but I don't have the up-to-date instructions.
Who is for the finance department here? Standing Council Finance?
Earlier, Barpujari represented Lordship.
Hmm?
Earlier, Barpujari Lordship.
Call Standing Council Finance. Where is the proposal? When was it sent?
The instructions are there in the court manual.
No, that is earlier instruction.
Earlier instruction.
There are, after the court order, there are development Lordship.
Hmm?
After the court order, dated Lordship 27 March, there are development Lordship. And that
What
instruction.
development?
Lordship, so far me Lordship, proposal was duly submitted before the finance department, and then Lordship, then also Lordship, thereafter Lordship, I have an instruction that some instruction have been given to the council by the finance department for proceed with the matter, Lordship. And Lordship, now the division is preparing, Lordship.
Mr. Gogoi, you can appear on behalf of finance. Now, is the finance a party here? Heritage
Yes,
is a
yes,
party.
Lordship, Lordship.
Finance is respondent free.
Madam.
The claim is for area salaries. Person was working in the Dimahasau
Madam.
as area salary of a late husband. There's a delay of 18 years. According to the Standing Council Dimahasau, the proposal has been sent, but it is pending before the finance department or maybe rejected.
Yes.
We don't know. Where is the proposal? Where are the particulars of the proposal?
It's there on record manual.
Which annexure?
What instruction was placed, madam? Earlier.
No instructions here. This 20 May. Is it 20th of May?
Yes, madam.
Recorded 20th of May. What in which one?
Madam, this
20th of May. What is the name of your late husband?
Horup Langthasa, Lordship. Horup Langthasa.
Where are the documents, bank passbook, medical certificate, police verification report? Is it available with you?
They are all submitted, Lordship. Actually, Lordship, the fact is that, Lordship, council appointed, Lordship, 10 numbers of persons, Lordship, under the executive engineer, Maibang division, Lordship. But they, due to some technical irregularities, Lordship, their salaries could not be, Lordship, released. Thereafter, Lordship, all the petitioners approached this honorable court, Lordship, and the honorable court directed, Lordship. Followed by the court order, Lordship.
We are now on the instructions, which is more than a year
Lordship.
earlier. Mr. Gogoi, do you have a copy of these instructions?
No, I can have the latest instruction audit.
You can have a look at the instructions.
Well.
If the name of the petitioner for the online proposal,
Well.
name of the petitioner's husband
Well,
was dropped because of the non-furnishing of certain documents
Lordship.
like bank passbook, medical certificate, police verification report, etc. So the online proposal was not submitted by the Principal Secretary, NC Hills.
Fine.
Now the question is whether NC Hills is in possession of these documents.
I'll take the up-to-date instructions, my lord. Because in the meantime, there was mediation also.
Mediation has failed because of the financial sanction not being there.
It's told that it was sent for finance, approval of the finance, but thereafter I don't have the up-to-date.
All right, we are recording your names. Please ensure that the instructions are available. Heard Mr. H. Talukdar for the petitioner, Mr. B. V. Gogoi, counsel for the finance department.
Yes.
And MS P. Chakraborty appearing for the NC Hills.
Fine.
And Mr. R. Dhor for PWD. The issue before this court is non-release of area salary payable to the late husband of the writ petitioner. Stop. On 14/8/25, the matter was referred for mediation. Stop. Subsequently, the mediator has placed a report saying that mediation has failed as financial sanction is pending with the finance department. Stop. From the case records, a communication from the Joint Secretary, Government of Assam Hills Department dated 20/05/2024, addressed to the Additional Senior Government Advocate, Assam, is available, from where it is seen that the proposal, online proposal for the sanction and payment of area salary of the late husband of the writ petitioner would not be proceeded with, as the late husband of the writ petitioner, as the husband of the late, as of the petitioner, late Orup Langthasa, expired in the year 2015, and his required documents like bank passbook, medical certificate and police verification report were not submitted by the concerned department of the NC Hills Autonomous Council to the Principal Secretary, North Kachar Hills Autonomous Council. So, the council for the finance department and the NC Hills are permitted 2 weeks' time to update, to apprise the court with updated instructions with regard to the status of any subsequent proposals being sent for payment of area salary of late Orup Langthasa to the petitioner, being his legal heir. Let these instructions be placed again before the court on 7th of January. Well, 7 January.
My lord, I'm sorry, my lord, regarding item number 7, the previous item, my lord, I was supposed to bring a record, my lord, regarding that register, my lord. The register, just now I have received this document, my lord, that my lord,
Not available.
my lord, it says that my lord, in 2022, there was a flood and all this was shifted. So right now they could not access it, my lord. Very short time was given. So I have spoken also, my lord, to them, my lord. So they need some time, my lord. Borpeta, my lord, so basically
They
it's a
need
flood,
some time to do what?
as to show, my lord, why we have, my lord, pasted that notice. Someone, my lord, fixing the date for
No,
DP.
you are supposed to give us whether it is your claim that the petitioner is not available. He is neither
He is not
in his
available.
Office.
He is not available.
What?
We have,
No, no, on what basis are the department furnishing you with these instructions if the old files and registers were damaged and found missing because of the flood?
my lord, my lord, I'm coming there, my lord.
Hmm.
My lord, he was transferred from his present place of posting. He did not join in the new posting. So, my lord, he was released and he did not join. So, my lord, if we technically, if we go into it even, my lord, he was not available in either of the office because he did not join. In his, that is why, my lord, this
No, no. You
DP
have,
proceeded,
you
my
have
lord.
initiated the proceedings. So it is your responsibility to see that the person is aware. If you issue an order, supposing we issue an order directing you to furnish instructions and this order is not communicated to you, how will the department be apprised of?
My lord, exactly, my lord. So what we did, my lord, we take all care. We could not contact him. We took out paper publication in all the leading papers, my lord. I have the paper clips in the record, my lord. Then, my lord, we pasted.
Therefore, we wanted to see the attendance register. Number one, whether pay slips has been prepared for him to get his salary.
No, my lord, he did not get any salary.
He did not get any salary.
Any salary. My lord, he did not join his new place of posting. So once he joins there only, then only, my lord, his pay slip will be issued from the new place of posting. He did not go there.
When was the last pay issued? Mr. Counsel, when was your last pay issued?
Lordship, it was in 2010, my lord. Because transfer order,
You did not face any difficulty because your
Lordship, because transfer order was issued,
you are an employee of the government.
Lordship.
You are getting a salary. Suddenly the salary is stopped.
Lordship.
Are you not facing any difficulty?
Lordship,
Do you have any other
probably he
sources
faced
of
the
income?
difficulty, but because of communication exchange, my lord. And so far as paper publication as claimed by the petitioner, that was not in connection with the disciplinary proceeding, my lord. Lordship, issue here is since disciplinary proceeding was instituted against the petitioner, my lord, that has to be as per rules, my lord. That is the main
No, it is their claim that you are not available. You are missing in action.
Because I have been my transfer order was issued illegally. I submitted revision. That revision was never considered by the authority.
Did you approach the authority to allow
Yes, my lord.
you to join?
Yes, my lord.
Where is
Because
that?
and even without handing over of
That provision is there. Unilateral charges can be taken over.
Lords. And because it is admitted fact that I did not join in a new place of posting, my lord.
No, in the old place, you did not want to come.
He was
back?
not available.
Lordship, even Lordship will find what they claim, my lord. Initially, inquiry was fixed on 2012, my lord. Subsequently, that day, inquiry was not held because of bond. And very next day, they conducted an inquiry without issuing a notice. That is the question. And now they claim that the notice was issued on 18. Lordship, Lordship will find it their affidavit. And at page 136.
First, show us where is the transfer order?
Transfer order, Lordship will find it. 43. This is a transfer order. By this order, first part, one UDA is transferred from Pathshala to Borbeta. And next page is petitioner was transferred to Pathshala, my lord, without permission, my lord.
He did not come challenging this order, my lord. This transfer order, my lord.
Let me see. Next because that transport order was issued at the behest of accounts officer. Normally, my lord, as a accounts officer is nowhere related to administrative function, my lord. How could he involve? That was the question also, my lord. Because and next 44 are submitted representation and detailed representation submitted that this transfer order is issued at the conspiracy of accounts officer. That representation remain pending and never considered. And this fact that this order was issued at the behest of accounts officer, that has been mentioned in the inquiry report, my lord. Even inquiry officer also admitted that that was issued at the behest of
You are attached as an LD.
yes, LDA.
LDA. Your services are governed by which rules?
Lordship district administration.
Yes.
Ministerial.
Ministerial dispute. Lordship, kindly look at the inquiry report for a moment, my lord. Page 70, my lord.
No appeal filed.
Appeal file, my lord. Appeal was
Appeal filed. Then how were you served with the inquiry report?
not served, my lord. After dismissal, that was served.
After dismissal? of-
Dismissal. Dismissal. Lordship will find the communication at page 77. Lordship entire approach right from the initiation of disciplinary proceeding till dismissal, including consideration of appeal is reversed the rule.
How was the inquiry report submitted?
Lordship, that will submitted by the inquiry officer by letter dated 1/10/2012 at page 69, my lord. Like, it is a settled position of law, my lord, since if disciplinary authority is not an inquiry officer, my lord, inquiry report has to be furnished to the delinquent before before making any mind or to punish, my lord.
My lord, that is why, my lord, we have been looking for him, my lord. He was playing hide and seek. He was not available.
But he received your inquiry report.
That was furnished to me.
You furnished him and his residence in his village.
Lordship, kindly look at
My
the
lord,
layer document.
then he received, my lord.
Ah.
But
Lord-
he did not join the my lord DP.
He-
He did not file his written statement, my lord.
Hmm.
Lordship will kindly look into page 136. This is the letter, this is the notice they
See-
claim to issue.
See, you have issued communication to him
All communication were received
as,
except the notice, my lord.
as PWD Borpeta Rural Road Division, LDA. But so far as the report is concerned, you have sent it to his residence.
Yes, my lord.
Inquiry report.
Yes, my lord.
Why? Because, my lord, after Shoko's notice, he did not turn up, my lord. We are not finding him. Then we went for a paper publication. That is why, my lord, we have to go to his residence. He has to join, my lord, the DP. He was shying away, my lord. He was playing every tricks to avoid the DP.
How could he say that I could not turn up?
All
Because-
right, but the fact remains that you did not serve him
Yes.
inquiry report.
Yes. Not only inquiry report, my lord, even after receipt of the lordship will find as per rule,
Where is the appellate order?
appellate order at 108, my lord.
108.
8. There is nothing consideration as mandated by rules 1964, particularly rule 23, my lord. Only on the basis of the reports, even that report also collected from the.
When were you likely to superannuate otherwise?
Lordship already suspended January 25,
Already superannuated.
31st of January.
Where is that furnishing of inquiry report communication again?
Lordship will page 77.
77.
My dismissal order was 28th of December 2012. And Lordship will find at page 77, this is the communication whereby inquiry report was communicated to me, that was issued on 9/1/2013 after the dismissal order was passed.
What were the orders passed in the earlier by the High Court? There are
Lordship,
three orders.
initially I challenged the transfer order, my lord, or dismissal order, my lord. That was somehow pending till 2018, my lord. And finally it was disposed of, directing the disposal of my appeal, my lord.
Then
During consideration, my lord,
there was a second writ petition filed.
Lordship, I am coming to it, my lord. During consideration, appeal was detected some defect, my lord, and accordingly, my lord, I file a contempt, and then department allow me, they applies the court that if new appeal is filed, my lord, then that will consider. Lordship will find at page 27, my lord, that is the order passed in contempt petition. my
So
lord.
page number 108 is the order passed pursuant to the court's order.
Lordship, even after filing of appeal, my lord, fresh appeal, that was not considered, and I had to approach this honorable court with fresh, my lord, writ petition, my lord. That was page 105, my lord. And after direction, it should be this honorable court, then only my appeal was disposed of by this speaking order. Lordship, if Lordship will go through the inquiry board, Lordship will say, so Lordship will find that there's no material witness or material evidence were taken into consideration. What they considered, by what the inquiry court considered during inquiry period, whether I received the notice or not, that much of consideration was there. And person against whom I made a complaint, that was made a witness, and that too, that evidence, his examination was done without giving my opportunity to cross-examine. And inquiry report clearly reflected that the executive engineer made a decision and instructed with an instruction note to the accounts officer Borpeta to issue transfer order to Dhanjit Das petitioner. That means that my apprehension was correct, my lord, because that is my transfer order was issued illegally by a person.
You should have challenged it.
Lord,
You did not challenge it.
Also, because I submitted representation before the
Whatever it may be,
Lordship.
it is not for you or for the department.
Yes.
I mean, it's not for you. You to take a call whether it is legal or illegal. If you are agreed, you come before the court. You
Yes.
did not come at the relevant point in time.
Possible.
You stayed away.
But finally, they instituted a departmental proceeding, but that has to be as per the rules. my lord. Lordship, as per rule 9, my lord. If disciplinary authority desire to impose punishment, then such it has to come.
Where is your appeal memo?
Lordship
appeal
appeal memo at page 84, 84, my lord. 84 to 104. 22. Rule 23 prescribe the procedure to consider the appeal, my lord. Rule 2, my lord, 2A, my lord, whether procedure prescribed in this rule has been complied with, or if not, whether such non-compliance has to be resulted in violation of any provision. My lord, appellate authority has to consider the appeal, my lord, independently without taking into consideration, my lord, any communication, my lord. But lordship will find entire appeal is disposed of on the basis of inquiry report and also report furnished by inquiry official itself.
Can you show from your records that inquiry report was furnished?
My lord, from the
And when?
My lord, on 18/9/12,
Hmm.
we refixed the, my lord, AP on 21/9/12. Then also he didn't turn up. On 18/9/12, we issued a, my lord, letter to Dhanjit Das.
No, this is prior to the submission of inquiry report.
After.
When was the inquiry, when is the inquiry report dated?
Inquiry report dated is, Lordship, 1/12, 1/12, my lord.
1/12.
Lordship, that's a communication, my lord, 69.
Huh?
Page 69. my lord. 1/10/2012, my lord. This is the letter of inquiry, my lord. Lordship, last final inquiry report, exhibit evidence 40, oral statement 9 of PWs, including statement of 3 numbers, joint statement of 3 numbers, oral statement of DW. Since I don't know, my lord, since it was expert, my lord, how could DW was examined? But if lordship will please to see, my lord,
Was the inquiry report submitted to him prior to?
My lord, he did not, we could not communicate only, my lord. Because there are 3 letters, my lord, all we have to put in his compound, my lord. Paper publication, then, my lord, on 14/9, we placed one in his compound. Again, on 18/9, we placed in his compound, pasted. And then there is again 11/9, three letters, my lord.
We are allowing this writ petition in parts. We are interfering with the appellate order, remanding it back to redecide on the grounds which are urged in the appeal memo.
lordship,
There are specific grounds urged. The appellate authority has not decided on this.
lordship, one more thing, my lord. Lordship, as per rule 9, my lord, if charge sheet is or show cause is served, my lord, is the mandated provision that documents which are sought to be relied.
Correct, but these are to be decided by the appellate authority. They have not decided all these. Let them decide it. This is a question of fact.
Yes, ma'am.
You say you are available, they say you have disappeared.
Lordship, they're trying to rely on the document. Lordship will find it page 1.
You have no answer as to how you have survived all these years without selling.
Lordship,
You did not challenge the termination order.
Lordship, kindly
He did not join.
look at
The transfer order.
Lordship, kindly look at page 1 document 136. Their document. They filed this affidavit, my lord. They rely upon this notice, my lord. They claim to be issues regarding my lord, inquiry held on 21st of September, my lord, 2018, my lord, or 12, my lord. Lordship, kindly see, matter was before the inquiry official, my lord. This is the letter issued by the receiving authority. My lord, may be a irregular, not a illegal, my lord. But maybe irregular, my lord. But lordship will find in last side in handwritten. Attached by the wall, on the wall of the house of LDA on 21st of 9, 2012, my lord. On the day which, my lord, expert inquiry was conducted. This is not my document, this is their document, my lord.
You point out before the appellate authority. We are disposing it off. Because you have already superannuated now.
Lordship.
So
Lordship, I have some.
these are matters of fact which can be looked into by the appellate authority.
Lordship, but
All the record.
apparently entire process was illegal, my lord. There is I realized.
We'll make these observations. Heard Mr. M. Bunto, Learned Counsel for the petitioner, Mr. R. Dhor. Mr. Dhor, we are allowing it in part.
My lord.
For the PWD. The petitioner before this court, who at the relevant point in time was serving as a lower division assistant under the executive engineer PWD Borpeta Rural Road Division. So by an order dated 19/5/2010, petitioner was transferred to Patsala Rural Road Division. Petitioner claims to have preferred a representation before the authority for reconsideration of the transfer order, which however was not considered by the authorities. Stop. It is the case of the petitioner projected before this court that while he was anticipating consideration and reply on his representation from the authorities concerned, by order dated 1/9/2012, the chief engineer appointed the inquiry officer and the presenting officer to inquire into the matter of transfer of the petitioner. Stop. Petitioner was subsequently issued a show cause notice dated 4/9/2012, asking the petitioner to show cause on the charges of misconduct and violation of official integrity. Stop. It is the contention on behalf of the petitioner that no list of witnesses, and no documents and list of witnesses as is required to be furnished with the show cause have been submitted to the petitioner along with the show cause notice. So, the petitioner thereafter represented before the authority seeking extension of time to furnish his reply. Stop. However, the inquiry officer however, the authorities did not furnish any reply granting further extension of time. Stop. The inquiry officer proceeded to conduct the inquiry and thereafter concluded the inquiry ex parte, the writ petitioner, holding the charges to be proved against the writ petitioner. Stop. Where is the report?
Lordship will report at case 70 minutes.
The inquiry officer in his report also recommended imposition of penalty by the competent authority under Rule 7 within bracket Roman 6 or Rule 7 within bracket Roman 7 of the Assam Services Discipline and Appeal Rules 1964. Correct. Pursuant to the submission of the inquiry report by order dated 28/12/2012, the petitioner was dismissed from service under Rule 7 within bracket Roman 7 of the Discipline and Appeal Rules 1964. Assam Services Discipline and Appeal Rules 1964. The petitioner thereafter preferred an appeal before the appellate authority also came to be dismissed. Therefore, present writ petition has been filed. Para. The respondents have contested the case, the writ petitioner, and have consistently maintained the stand that pursuant to the order of transfer issued to the writ petitioner, he deliberately refused to comply with the order and abstained from joining in his place of posting. So, in spite of notices issued, he declined to participate in the inquiry and left with no alternative. The respondent authorities had attempted to serve notice by way of substituted service by publication in local newspapers. Stop. The notices were also affixed in his last place of posting as well as in his in the office, as well as last place of posting in the office, as well as in his place of residence, the address of which is available with the writ petitioner, with the department. Stop. Nevertheless, the petitioner did not participate. Therefore, the inquiry officer proceeded ex parte and concluded the inquiry, which was thereafter submitted to the disciplinary authority. Stop. Disciplinary authority, on the basis of the inquiry report submitted, impose punishments under rule so and so so and so. Stop. The appeal preferred by the writ petitioner also came to be dismissed. So, they submitted that the contention of the petitioner that the procedure prescribed under the rules of 1964 have been flouted, and that the petitioner was not given opportunity to participate. He is completely denied, in as much as, in spite of notices being issued to the petitioner, the petitioner refrained from attending the inquiry and did not participate in the inquiry by filing the written statements or producing any witnesses. Did not participate in the inquiry. Stop. It is therefore submitted that there is no merit in the petition and the same should be dismissed. Learned counsel for the parties have been heard. Pleadings available on record are carefully perused. Stop. The challenge in the present writ petition is to the departmental proceedings initiated, the inquiry report submitted, the order of termination issued by the disciplinary authority, as also the rejection of the appeal filed by the writ petitioner. Stop. Par contra, the respondents have maintained their stand that in spite of sincere efforts to serve notices on the writ petitioner, he having abstained from attending to his duties in his places of posting, the notices served in his last known place of service or residence were duly served in his last name place of service as well as residence, and as also through newspaper publications. Stop. Correct. There is no dispute that the department is subservient to the Assam Services Discipline and Appeal Rules 1964. The rules are elaborate and the procedure prescribed under the rules for imposition of major penalty like dismissal or termination under Rule 7 is prescribed under Rule 9 of the same rules. The show cause which was served on the writ petitioner, copy of which is available. Where is the show cause? Page number?
Page 64, my lord.
64. Copy of which is available in the pleadings before the court. Reflects that the state show cause is accompanied by the statement of allegation. So there is no list of witnesses or documents enclosed to the show cause notice, as is required to be done under the rules of 1964. Stop. While the petitioner maintains that his applications for extension of time for filing WS was not replied to by the authorities concerned, the responding authorities on the other end submits the categorical stand of the respondent authorities on the other hand is that the due intimation and proper notice was issued to the petitioner for participating in the inquiry process. However, he abstained from filing his WS as also participating in the inquiry process. As a consequence thereof, the notices were required to be served through substituted service. So, whether the petitioner deliberately abstained from joining in his place of posting and as a consequence whereof the respondents could not serve the notices as claimed are matters which will be relevant from the records which are available with the department stock. On 4/12/2025, the respondent counsel was given liberty to apprise the court as to the availability of attendance registrars and any other official documents to show as to whether that the petitioner was not available in his places of posting and service, or whether the petitioner was required to sign his attendance registrars in his earlier place of posting or present place of posting. So, Mr. Dhor, the standing counsel, PWD, on instruction submits that these are all records, and because of flood, because the division of what division is this? Borpeta? Huh? Borpeta or what?
Borpeta, madam.
So it has,
The
it
letter
says
of-
Borpeta, Mandia and Chenga.
Madam, now it is 3, madam.
Erstwhile it was.
Earlier it was what? Borpeta.
Yes.
The Borpeta division was affected by floods, severe floods in 2022, due to which some older files and registers were damaged and were found missing. And therefore, the requisite employees attendance register for the months of July 2012 to October 2012 is not currently accessible to the division. So, copy of the said communication is kept in the case report. So, under such circumstances, certain disputed questions of facts are being presented before this court with the specific particulars as to the presence or the attendance of the writ petitioner in his places of posting and service, or end of leave, or his absence therefrom, and also as to whether the notices claimed to have been issued by the department were received or served on the writ petitioner, and also as to whether the petitioner refused to attend his places of posting at all. Stop. What is noticed by the court is that, being agreed by the order of termination issued by the disciplinary authority, an appeal was filed before the statutory appellate authority, and which appellate authority, by order dated 23rd of April 2024, rejected the appeal preferred by the writ petitioner. Stop. In the appeal memo, which is filed by the writ petitioner, a perusal of the same reveals that specific grounds have been taken by the petitioner in respect of the case projected before this court. So, it was specifically pleaded that official communications documents were not furnished, the charges made in the charge sheet were vague. Stop. No adequate opportunity was permitted, was granted to defend the charges. Stop. The list of witnesses and documents relied upon by the inquiry during the inquiry were not furnished. Stop. The inquiry report reveals 40 numbers of exhibits, 9 numbers of prosecution witnesses, including 1 number of defense witnesses. Stop. The grounds taken by the petitioner in the appeal is that no defense witness was ever produced by the petitioner before the inquiry officer. Stop. The further ground urged is that prior to the issuance of the termination order by the disciplinary authority, no copy of the inquiry report was furnished on the writ petitioner, as is mandatorily required under the rules. A bare perusal of the order passed by the appellate authority reflects that these grounds were not specifically dealt with by the appellate authority. For convenience, the grounds urged before the court are extracted below. Page 92, 93, 94, mark for as an extract for you. These grounds, which were specifically urged, were required to be dealt with by the appellate authority, as these are matters of fact which are required to be decided by calling for appropriate records and examination of the necessary exhibits or the witnesses to come to a conclusion whether the grounds urged were whether these grounds were validly urged before the appellate authority. So, however, the impugned order passed by the appellate authority does not reflect that the appellate authority had addressed these grounds specifically, either by accepting or by rejecting the same. So, the appellate order does not contain any reference to these grounds urged. So, the law in respect of service of the inquiry report on the writ petitioner has been elaborately explained by the apex court in
Lordship, 1993, my lord, 4 SCC,
What is it?
727.
What is the name of this
Perhaps
part?
ECL,
Huh?
ECL, my lord.
ECL.
1993,
ECL
4
judgment
SCC,
reported in
93,
4 SCC
727, my lord.
727 and all the subsequent judgments which have been referred to, which have been rendered by the apex court time and again. So, the law in this regard is crystal clear that non-service of inquiry report on the petitioner, on the delinquent officer, prior to issuance of the
Prior to consideration of that inquiry.
order passed by the department, by the disciplinary authority, would be fatal and would not withstand the scrutiny of law. Stop. What is also noticed by the court is that under service jurisprudence and also specified under the rules of 1964, the inquiry officer is required to conduct the inquiry in respect of the charges leveled against the writ petitioner and submit before the disciplinary authority the conclusions of the inquiry officer with regard to these charges framed against the writ petitioner. Stop. The inquiry officer is not to recommend imposition of punishment under Rule 9, under Rule 7 of the rules of 1964. So this is the ambit reserved for the disciplinary authority. Stop. The disciplinary authority may or may not agree and accept the conclusions arrived at by the inquiry officer. Stop. In the event the inquiry officer, the disciplinary authority disagrees with the conclusions arrived at by the inquiry officer, then the procedure to be followed is prescribed under Rule 9 capital A of the rules of 1964. Stop. However, the appellate authority did not address this issue as well, which is on the face of it contrary to the rules prescribed under 1964.
I have one more issue, my lord.
The purpose of the inquiry instituted against the delinquent officer is to enable a fair and unbiased inquiry proceedings to be initiated against the delinquent officer in respect of the charges, in respect of the allegations made against the delinquent officer, and by way of the show cause notice. So, whether these allegations are found to be proved or partially proved or not proved is to be the conclusion, is to be decided on the basis of the conclusions arrived at by the inquiry officer. Stop. What consequential orders and actions are required to be undertaken by the disciplinary authority is to be left to the is left to the discretion of the disciplinary authority. So, better. The question, therefore, before this court is whether the appellate authority is empowered to look into the entire gamut of the inquiry proceedings undertaken and the extent of the orders that may be passed by the appellate authority. In this regard, reference may be made to so-and-so versus so-and-so reported in so-and-so, where it was elaborately laid down that the powers of the appellate authority are akin to that of the disciplinary authority. So, whatever orders the disciplinary authority can pass under the rules, is also reserved for the appellate authority if the appellate authority finds that the inquiry proceedings conducted were not as per the procedure prescribed under the rules of 1964. So, this apparently was not done by the appellate authority, as is evident from the fair reading of the speaking order dated 23rd of April 2024. So, under such circumstances, this court is inclined, therefore, to allow the writ petition in part, interfering the impugned speaking order dated so-and-so passed by the appellate authorities. So, the said order is therefore set aside. So, the matter is remanded back to the appellate authority to redecide the appeal preferred by the writ petitioner by taking into consideration all the grounds urged and by calling for all relevant records, witnesses, and obligor documents as may be considered necessary for passing a reasoned order. Stop. Any such order that is passed, the copy thereof shall be served on the writ petitioner. Stop. Needless to say, the petitioner will also be given a right of hearing, as also for all other affected parties. So, the appellate authority will proceed to rehear the matter as directed within a period of 30 days from the date of receipt of a certified copy, and will expeditiously conclude the hearing within the outer limit of 90 days from the date the appellate authority proceeds to hear the matter. So, as it is submitted by the writ petition that he has already crossed the age of superannuation, no orders are necessary for reinstatement or keeping the petitioner under suspension. In the event the appellate authority interferes with or modifies the order of punishment, the order passed by the appellate authority, disciplinary authority, all consequential service and financial benefits shall be allowed to the writ petitioner. With the above observation, writ petition stands allowed in part and disposed of as directed. The records placed before the court are returned back to the Learned Standing Council, PWD.
Hello.
Yes, you wanted to say something?
Lordship, one more irregularity is there, since Lordship.
One more?
Irregularity there, that in normally in inquiry proceeding, there cannot be witness by disciplinary authority and testify his testimony, my lord. But in this case, my lord, disciplinary authority himself is a witness, which is quite illegal, my lord.
You urge all that before the appellate authority.
Item 9.
Yes.
Also, the petitioner aggrieved by the rejection of the pension on the ground that the service of the petitioner was not regularized, lordship. In this matter, lordship, earlier also the petitioner in the year of 1991, the petitioner along with others were terminated from the service. But again, this petitioner approached this honorable court and lordship 29/1/1993, that is page number 20, lordship. This honorable court has, while reinstating the petitioner, directed the state government to verify the vacancy position and frame a scheme for the regularization, lordship. Lordship, on the view of that, the petitioner was working there, and when the petitioner was retired on 31/12/22, the petitioner was informed that the petitioner post was not regularized, lordship.
Yes. Pleadings are complete.
Pleadings are complete, lordship.
You are claiming regularization on what?
Regulation of the lordship, the petitioner was a work just as a section assistant, lordship. Was retired on 31/12/22, lordship.
Where is your order of appointment?
Lordship,
Order of appointment?
ordered appointment, lordship, 1986, lordship, and subsequently the
Page,
petition-
page number.
Yes, lordship. 20. Lordship, 23, lordship.
Where is your name?
Lordship, Narayan Chandra Bora, lordship.
Only one petitioner.
Lordship, only one petitioner, lordship. That is, lordship, subsequent to the order of this honorable court.
Now then what happened? Regularization, you are regularized.
No, lordship.
Then
The lordship, this is the subsequent to the honorable high court's order, lordship. That is page number 20, lordship. Kindly come to page number 20 first, lordship.
20?
Page number 20.
Yes.
Lordship, here the petitioners were terminated. The petitioner approached this honorable court and while ordered this order 29/1/93, the lordship, kindly page number 21 starts from last paragraph, lordship. Page number 21, last paragraph. The petition is disposed of in terms of the following order. The state government of the Assam is to, lordship, the state government of the Assam is to verify the vacancy position of the category of daily labor, casual laborers, master role worker in the Karbi Anglong division and frame the scheme in a fair and just manner for the regulation of 18 petitioners named above, having regard to the length of service and other relevant conditions, including the prescribed qualifications. After this order, lordship, the petitioner again joined in the post, lordship. That is page number 23. Petitioner was under reparation, lordship. Pursuant this honorable high court's order, his service might be regularized, lordship. And he came to know only when his survey, he was superannuated on 31/12/20, when his pension proposal were rejected, saying that his service is not regularized, lordship. Page number 68, Lordship. Impugn order is page number 68.
Page number 28,
68, Lordship, impugn order.
68. No. Yes,
Reference to the above, I am to return here with the pension proposal.
because you're not regularized. What is your prayer now?
Lordship, to regularize and the paid pension of the petitioner, Lordship. As pursuant to the order of the Honorable High Court, the petitioner service is to be regularized and accordingly.
Where is that specific direction?
Lordship, I have just read, Lordship, before. That is page number 20.
Hmm?
21, Lordship. I have just read, Lordship, which were. The specific direction was there in this.
Where is that?
Page number 21,
Read it.
Lordship. The expression, last paragraph, Lordship. The expression a fairly long spell has been translated by the Supreme Court into the 3 years. Keeping in view of above decision of the Supreme Court, the petition is disposed of the terms of the following order. The state government of the Assam is to verify the vacancy position of the category of daily labor, casual laborer, master role worker in the Karbi Anglong division irrigation and frame a scheme in a fair and just manner for a regularization of 18 petitioners named above, having regard to the length of the service and other relevant conditions, including prescribed qualification, if any. This is the specific direction, Lordship.
So what happened? You did not file a contempt.
Lordship, the petitioner did not file any contempt. He was under impression, he was,
What orders you want now?
Lordship, to regularize the service of that.
You want a similar reiteration of the same order? Once an order is issued by the court, it is issued. Why should we are not the executing court.
Yes, Lordship, but
Then-
the rejection of the pension, Lordship, on the ground that.
There is an order. What have you done with this order?
Lordship, the petitioner-
You had, the court had passed an order in your favor. What did you do with it?
Lordship, the petitioner accordingly joined and he was in the service and he was under the impression his service is regularized.
So impressions don't help.
There's nothing communication that the petitioner service was not regularized by the department.
You
also.
show us from some authority that now we can again reopen this issue and issue fresh directions. This is an order, it has been directed. There was a specific time frame within 6 months. Scheme to be framed within 6 months. What have you done? And why have you come now in 23?
Is the petition.
This order was passed when?
Lordship, this is 18.
93. 93. And you come to the court again in 23.
When the petitioner came to know that Lordship, his pension has been rejected on the ground that his service is not regularized.
You must have dragged the petitioner to court. No. The 93 order, you come for compliance in 23. On what basis? Tell us.
Now the thing is the petitioner has superannuated. He was serviced for the last 30 years, Lordship. His service has to be regularized and he can.
The directions you are seeking cannot be issued now. Yes, respondents?
As petitioner is not regularized, he is not entitled for pension, my lord.
Huh?
As petitioner is not regularized in his service, my lord, he is not entitled for any
That's
pension,
right,
my
but
lord.
why did you not comply with the direction of the court earlier issued?
My lord, it is the matter, the appointment and other matters of the sixth schedule area of the autonomous council is completely under power of this autonomous council, my lord. So,
Who's
at that
for
time,
autonomous council?
the Karbi Anglong autonomous council.
Why have you not complied with this order of 1993?
He was appointed thereafter, Lordship.
He was appointed, he was directed to verify position, frame a scheme for regularization. And their age bar shall be waived, reservation rules to be complied with, scheme to be framed within 6 months. What did you do? You allowed him to work. Give us an authority that we can proceed, reopen this matter.
Lordship, there are authority, but I don't have now. Lordship, give me another date, I'll place the authority, Lordship.
My lord, petitioner was initially appointed as my lord temporary basis. My lord, this is reflected in page number 23, my lord. His appointment is
Was he
temporary.
regularized or not?
No, my lord.
It's not
He's
regularized.
not regularized, my lord.
Never.
No, not regularized, my lord. So as per Umadevi and Upenda's case, he's not, and he has no right to be appointed regularly, my lord. My lord, initially government, his service was, initially he was appointed in 1986 and he was terminated in 1991, my lord. Thereafter, he was reappointed 27/7 to 1993 as per order of this honorable court, my lord. Thereafter, he was not regularized, he not even come to the court. This order is time barred, my lord.
Where is the office memorandum 6th of September? You are not prepared. List again after 4 weeks, enabling the council to address the court properly. MS so and so, so and so, so and so, they pays for the respondents.
My lord, yeah, in the particular case, my lord, my item, my lord, my learned brother has allowed me to access the.
No, you are appearing for, first is item 10. Who's for item 10?
Item 10, I'm appearing.
What is your claim?
My lord, my claim is, my candidacy was rejected, my lord, on the ground that I have not the benchmark disability. That is the only reason.
Your case was?
Rejected, my lord. My candidacy was rejected, that I have not met the benchmark disability, my lord, 40%. I have seen the record, my lord. It was around 14 or 16% in one case, my lord.
All right, now, Mr. Gogoi, as far as I recollect, the issue was one in view of this ID card and the certificate.
Yes, they participated.
They participated, and then you subjected them again.
No, only the selected ones, my lord.
Selected one.
My lord.
Then the question would be, what is be the value of this certificate where it is clearly written that they have benchmark disability?
My lord, here, that part, my lord, there is a notification, which is, I put to challenge here in, my lord, where it says that, my lord, after selection of a person with benchmark disability, before appointment, they will have to undergo this particular. And now, my lord, in fact, twice if they have been examined, and twice it has been found that, my lord, they are below.
Therefore, the question now is, let us say, give an example, a person with having difficulty in eye.
My lord.
On a particular time, because of whatever reasons, it was found to be above 40%.
My lord.
Subsequently, because of treatment or medication, it may have improved.
My lord.
There could be possibilities.
Yes, my lord.
But people with locomotor disability, hearing disability.
Hearing also it improves, my lord.
No.
They call it a progressive disability, my lord, not a temporary or what I would say, man. Is that benchmark of 40 and above. Maybe, my lord, it may go down also. There are, my lord, instances. My lord. In fact, in medical courses, my lord, they have found. Where also, my lord, similar, my lord, examination has to be faced by the
Some authority will have to give a finding that the certificates which were issued are not sufficient to give them the benefit for all times to come. These are subject to scrutiny.
Yes.
Now, let us say, because you reject some selected person on the ground of evaluation, what will be the value of that certificate, which they may again be entitled to apply for new recruitment?
That perhaps, my lord, government will have to take a call, my lord, whether it will have to be, otherwise, if not cancel, my lord, yes, they will, they will apply and, my lord, take the benefit of that particular certificate. But one thing, my lord, the certificates, my lord, the benefit is not limited to having an appointment under a particular quota. There are other benefits, my lord, which are they can avail otherwise, right from education to having various trainings and all. It is there in the act.
What I'm saying, the
Well,
very,
there are two
the
things, my
very
lord.
basis of the claim or
No,
presenting
my
themselves
lord,
for the
may I
claim
clarify, my lord,
is
there are
the certificate.
There are two aspects, my lord. One thing is, my lord, giving the various benefits under the particular act. Next is reservation. Reservation says, my lord, it will have to be a benchmark disability of the specified disabilities.
Mm.
They are in the schedule. That is very clear, my lord. And it will have to be above 40. Reservation part only. Rest benefit they can avail, my lord. Even, my lord, a disability having 5% disability, he will get the benefit. Whatever other benefits are concerned, my lord, they are in the act as well as the various policies of the government. But to have them, my lord,
Now this specific recruitment is specifically directed to benchmark disabilities.
no, not, my lord, it was a general, my lord. No.
This in respect of our case only is a special recruitment for physically disabled.
Not in not all case, my
for
lord.
No, all the cases.
Only in their case. No, not in all.
More case belongs to special recruitment.
My lord, ultimately, my lord, whatever vacancy has now arisen from, my lord, because of, my lord, getting the, my lord, filled up by this particular petitioners, it has been given to other persons of the same, my lord, category. The question of, my lord, discriminating or depriving them doesn't arise, my lord. Our entire effort is, my lord, that the right person should get the job, who is actually disabled, having,
This certificate
my lord.
is under a statute. There is an authority identified who is responsible for giving that certificate.
My lord.
It is that certificate which gives them the right to be included or considered for
Yes.
these reservations.
Yes, sir.
Now, once they are in the reservation, let us take a case of vertical reservations.
My lord.
Somebody belongs to SC. He comes with a certificate.
My lord.
He is an SC, he applies.
Yes, please.
At the time of after being selected, if he is subjected to another scrutiny to find out, and some authority says that no, that caste was originally SC, now it is not, or partially it is not.
There are cases where such persons have been released from service, madam. It's not that.
Where it is
if
false,
found-
etc., it's a different issue.
There are cases before the honorable.
What
court
I'm
is
trying to-
pending.
What I want to understand from you is that the very eligibility gets
For appointment,
rejected.
it goes otherwise, yes. For, at least for this.
Then what is the meaning of the certificate given by that authority?
No, that's
under
why I said, my lord, that certificate is not only for appointment. They nowhere it is stated that, my lord, this particular certificate is issued so that he can apply for
It
appointment.
need not be. It
Yes.
need not be. But can you choose that this certificate is 40% disability for everything else, but not for appointment? Can you say that?
No, I'm
It
not
has
saying
to
that,
be
my lord.
that
The question is, my
disability-
lord,
That disability is been identified by an authority notified under the
no,
Disability
my lord, we are going by the notification of the, my lord, Home and Political Department. It's there.
state of Assam.
Yes, my lord. Following, my lord, the notification of the central government. And it says, my lord, this
Where is
notification.
that notification of central government?
Yes, it is there. But my one thing, my lord, if at all, my lord, they are so, my lord, if they won, my lord, they can go for a third also, my lord. At least if they won, my lord, just to see, my lord, third, my lord, evaluation, my lord, we are ready to do that. Provided they make themselves, my lord, we no intention of the government to deprive a, my lord, deserving person. If they won, if they agree, my lord.
Under the supervision of my lord, any
No,
doctor
see.
nominated by your lordship.
Disability which are progressive, you may classify it and say that X1 to X2 categories are disability, progressive disability. On a day when it was found, there was 40%.
My lord.
Today it may be less. Tomorrow it could still be more. But that yardstick you'll have to identify those criteria and say that these are the candidates who are suffering from these kind of progressive disabilities which will require re-evaluation.
But my lord, in fact, my lord, now when entire lot was, my lord, examined, they voluntarily participated without any demand.
No.
And it has been found, my lord, no, that even the permanent disabled, my lord, certificates.
Lot may be examined. We have no difficulty with that.
Yes.
But in the results which were declared, you have to identify that
My lord,
these
yes,
persons
by the board also, my lord.
Ah.
Yes. So that, yes, in future they may, in that case.
yes, that these are the candidates who had progressive disability, and upon examination once or twice or thrice, we found them, these parameters are less than the benchmark.
My lord, my lord, my lord.
That certificate, that thing must be
Perhaps,
there.
yes, there it may
Somebody is
benefit,
accountable for that.
benefit someone, my lord.
Sorry?
It may in future benefit someone, but yes, of course, my lord. If that is done, my lord, by expert body, that opinion is given. That,
Where
my
is
lord,
the
we-
central government notification?
Yes. My lord, if lordship takes up, my lord, 2-3 tomorrow, nothing will be.
It's not here?
My lord,
Mr.
In
Khattar?
item number 10, they have not filed any affidavit.
No, in some cases, my lord, it has been put to challenge. Lordship will see, my lord, 2301.
2301, what is the item number?
Yes.
26.
Post going to the central notification, my lord, I like to apprise one point, my lord, in item number. My item, my lord, the first item, that is item number 10, my lord. Oh, 11, sorry. 11. Yeah, my lord, what happened, my lord? I have been discarded twice, my lord. But during pendency of the case, my lord, he got a severe problem. He cannot hear, my lord, even a sound. Again, my lord, he has to go to medical college, medical examine and found my lord and gave him the same also. And I have brought him to record bio of everything. Item number 11.
All right, we'll come to
In,
you.
Yes.
in WPC 2301, we have filed one additional affidavit. It is page 141, there is a running page number. This is a OM of the Central Government Ministry of Personnel, Public Grievances and Pension Department of Personnel and Training, 15 January 2018. Clause 5 speaks about that. And at the very, my lord, introduction, it has been stated that, my lord, this has been issued following, my lord, the provisions of the Act and the rules of 2017, 16 and 17.
Clause 5.
Clause 5 at page 142.
Oh.
A person who wants to avail the benefit of reservation will have to submit a certificate of disability issued by a competent authority. Such certificate in the event of selection of such person for any post will be subject to such verification / re-verification as may be decided by the competent authority. Now, my lord, following this, my lord, the state has also issued one notification at page 149, which is under challenge before the honorable. This is the notification of OM from the personnel department, personnel B department. And page 150 is the clause 5, and perimeter is a clause 1.
Is central government notification, is it under challenge?
No. You have stated, my lord, in fact, my lord.
After our recruitment, most probably, yes.
No, 19, 7th of January 19.
The advertisement is of 30th of December 2018, my lord.
Amar Pisolo. After us.
What is 7th of January?
My lord, page
The
149.
2149.
My-
And what is 21/5/22?
22, my lord. 22. It was further and modified. Yes, 21st of May, my lord.
21st of May.
It was further modified, but not clause 5. Some modifications were made and again it was republished on 21st of May. So as on that, these are the my lord, OMs which are holding the field.
And what do you say with regard to the judgments which
Yes,
are?
in fact, my lord, the review has been dismissed.
That we know.
And my lord, presently, my lord, it is before the division bench under appeal. Delay has been probably condoned, or no, delay notice has been issued. It is yet to be numbered.
Who has filed the appeal?
My lord. My lord,
You have filed
he
the
is the
appeal.
counsel who is pursuing in the division bench.
You have filed the appeal.
Yes. Well, delay has, they took time for filing objection. But that is not the, my lord, I have submitted one judgment letter in the.
Hmm?
Earlier, I have submitted one judgment in suo motu. In suo motu, there are various cases, my lord. But in that cases, my lord, what they have, may have the justification for denial of a candidate selected in the, from the select list without considering their merit. Every justification has been negated by the Honorable Apex Court and including that the similar petition has been dismissed by Madras High Court and it was went to the Supreme Court and Supreme
You are
Court-
referring to the judgment of which? Rekha Sharma?
No, my lord, in the.
আপনি কয়জন পাওয়া না লাগে তো পিছে দেখো মুখে টুপি না ডেভেলপ না কি বলে বলে
Where is that? Where is that? You serve them a copy?
Yes.
Have you seen the judgment?
My lord,
What is referred to?
I am primarily referring three judgment. One in re, my lord, and Lieutenant Colonel Nitisha.
No, first you refer to the, three judgments you can't refer simultaneously.
Yes.
Which one do you want to refer?
Go by this judgment. No, dispute are the judgment.
You serve a copy to the Government Council or give him a list of the judgments at least.
I have already served, but every time.
The problem is that you are not going digital. You serve by email, keep a record. Why are you not using the facility of emails? Instead of making physical copies and serving them ever and ever again, including the court, you can send it to the court master. Even we don't have that judgment. Give us the citation.
Yes. My lord, I will primarily rely three judgment.
Oh, we have heard you.
Yes.
You give the list of judgments that you want.
Judgment, my lord, 2025 for SCCR 222.
for SCS. Here.
And it was a 2025 INSC page 300.
2025.
You give them the list. You share the list immediately to the court master. We'll come back at 2. Writ petition allowed, disposed of. No order is to costs. Records, if any, be remitted back forthwith.
Thank you.
Yes. Oops.
My lord, I have served the copy, my lord. My lord, before I start the three judgment, my lord, what your lordship asks, my lord, regarding the fluctuate of the my lord, quantification or percentage of disability, my lord. May I read one paragraph of a judgment, my lord? It is Om Rathod case, my lord. Paragraph 54.
Read it.
The disability of a person is quantified at the time of availing a unique disability ID. The quantification
Your-
of disability,
Which judgment you're reading?
my lord, 2024 10 SCR 1287.
Om Rathore,
Yes, my lord.
page, paragraph
Paragraph 54.
54.
My lord.
No,
But this is in respect of the section 32, my lord, not 34. The disability of a person is quantified at the time of availing a unique disability ID card. The quantification of disability is moved at the point of admission to educational courses, since the eligibility for a person to benefit from reservation may be evaluated using the quantification in the UDID card. If a person with disability wants to have themselves reassessed so as to verify whether their disability falls within the prescribed parameter for reservation, they may choose to do so by updating their UDID cards. The role of disability assessment boards must be tailored with a functional competency approach only for the course which the candidate seeks to pursue. So, if I required, my lord, even if in section 34, there is no question of disability assessment board. This disability assessment has been recognized by the apex court in respect of section 32. Because in Om Ransara Gon,
what is the meaning of this paragraph that you have read?
yeah, my lord, the disability assessment board only can see, my lord, whether he can pursue the course or not, or he can function in the post or not.
How does it answer the query raised?
My lord?
How does it answer the query that we have raised?
Yes, my lord. Here, my lord, if you look at paragraph 2, my lord.
Where is Mr. Gogoi?
Lordship, he is in court 10, Lordship, he'll come, Lordship.
Have you gone through the judgments? Address the court on this judgment.
Paragraph 2, my lord.
Yes, paragraph 2.
We answered this question by rooting them in the web of constitutional law principles, statute, regulatory framework, and guidelines which are germane for this case. The bone contention before us turns on the manner in which the disability assessment boards must function while certifying the eligibility of a candidate for the MBBS course. The applicant has lower limb myopathy, a locomotor disability. The applicant has been an academic success. He secured an A1 grade in his matriculate and intermediate examination held by the Central Board of Secondary Education. He aspires now to enter the medical profession. With this result, the applicant appeared for the NEET examination 2024 on so under the unreserved EWS PWD category and secured 601 marks out of total marks. This placed the applicant at an All India PWD rank 84 and the state PWD rank 4. Despite having a disability certificate dated so which was to be valid until 2025, the applicant submitted himself to the mandatory assessment to get his eligibility certified by a designated medical board at AIMS, Nagpur, of the guidelines regarding admission of students with specific disability under the Right of Persons with Disabilities Act 2016 with respect to admission in MBBS course prescribes that person having over 80% disability may be admitted to a medical course on a case-by-case basis after assessing their functional competence to navigate academic and practical requirements. If you're regarding the only disability based, your lordship is asked to clear the further point, my lord. May I submit another judgment?
You are reading from judgments without any reference to the issues raised. What do you understand? How is this applicable here? You have referred to this paragraph.
Yes.
How, what do you understand by that?
My lord, the disability assessment board,
Huh?
they can only see whether he could functional competency, whether he could,
This is not what is expressed in para 3.
yes, because this is,
Para 2 and para 3, you read it properly. Is this what is the facts of the case? No.
but it is regarding the admission. But
See, Mr. Counsel,
Yes.
you, time and again you
Yes.
appear, you
Lord,
jump from
my
one
lord.
person to other,
Correct.
you waste judicial time. You, whatever you have to submit, you first read the judgment, explain that these are the facts in which the judgment was rendered. These are the facts which are similar to the facts in the case in hand, and this is how it is applicable. You have to explain. You can't just pick up a paragraph and say that this is applicable. In what context?
regarding the ratio, my lord, disability assessment board.
Ratio,
But-
you have read only 2 paragraphs and you say that this is a judgment of
Section 32 in it, sir.
63 paragraphs, and you read 2 paragraphs to say that this is the ratio.
It is in respect of section 33, okay, 32 one. Then, my lord, may I come, my lord, section 34 on the point.
No, don't come like that. You are referring to the judgment, you read
Yes.
the judgment and you tell
Yes.
us what is the judgment there for.
May I read, my lord?
You have not read this judgment. You have not read this judgment. You have not read any of these judgments.
I have read, my lord.
No. You
Please
have
judgment I
only
have
read those paragraphs which you think are relevant. The entire judgment you have not read. That is the problem.
But if I read, my lord, the entire time will go, my.
You read and tell us. That's the reason why counsels are permitted to address the court. You read the judgment. Tell us that in paragraph this is the case, this is the law, these are the references, so that we don't waste time reading it. You have read only that paragraph which according to you is relevant. That's all. To understand the judgment in the order of the court or judgment of the court, in relation to that, we must understand what are the facts, what happened, how the matter came up before the Supreme Court, what was held by the High Court.
Then I have to read, my lord.
Then
Because in this case, my
how
lord,
can you address the court without even reading a judgment?
agreed by this, my lord, paragraph.
Yes, any other counsel who wants to address the court?
My lord, then this is.
No,
No, my
don't
lord.
address the court unless you read.
My lord, I have read in
No, you
in-
read all your judgments. You are referring to all the judgments. Why have you referred to without reading it?
Because they have that, they quantified, they whether they can assess or not, my lord. My lord, in re, my lord.
Yes, government, what do you say? Have you received a copy of these judgments?
Lordship, this judgment, Lordship, I have received just now, Lordship, but it pertains to Lordship, medical admission, Lordship.
Yes, that's why I have said, my lord. But here, in
We expect young counsels
Lordship, this
to
is,
rise, lead, address the court. Don't turn out to be disappointments.
yes. And Lordship, the
Actually-
conclusion,
Yes, Mr. Barbuya and Mr. Khatuniar. This is not a forum, social forum that you'll come here and spend the whole day saying whatever you feel like and will record it.
kindly,
This
my
is,
lord,
this
three
is
judgment.
something we are deciding on the rights and privileges of the petitioners who are before the court.
Yes, my lord. Because,
Take it seriously.
because only I have referred, my lord, I referred 3 judgment, my lord. May I allow to read, my lord?
You have not read the judgments, you have admitted. We can't permit you to read the judgments now, understand and then explain to us.
I have read in.
No.
three judgment.
We don't trust you on this. Come back. Read it properly and come back.
Yes.
Yes,
My lord,
Mr. Barbuya,
Lord,
tell us.
Take up, my lord, item number 11, my lord.
Wastage of time.
Item number 11, my lord.
Yes,
We have been discarded by the medical, so-called medical constitution.
you are agreeable to appearing before the authorities again.
My lord, I want to appear, my lord.
You want
If
to.
your lordship, my lord, desires, my lord, by a substitute committee, my lord, by a fixing by your lordship, my lord, as the standing council apprised, my lord. To that effect, I am agreeable, my lord. There must be a board, my lord,
Yes.
constituted by your lordship, my lord.
Lordship, that can be done, Lordship.
Constituted, what is your disability?
This one, my lord, hearing disability.
Hearing I and Lordship.
How many petitioners?
There are only one petitioner, one case, my lord. Item number 1 is a 11 is a here. Number 12 is a itu ki Ranjana Devi. Ranjana Devi. Number 2 is a vision. Then next also vision 13. Beauty. Beauty is hearing. And Swadhani hearing.
No,
Vision.
vision.
And locomotor 24 is the locomotor.
ECD.
I'll give a small note, my lord, in respect of my.
Give it.
Yes, my lord, right now I'm giving.
Give it.
Who is what, my? Lick it, yeah, ma.
Give it to us.
And during pendency of the writ petition, my lord, the petitioner before your lordship, item number 11, my lord, he was compelled to go to the medical college for examination or immediate records of his treatment, my lord, because he cannot hear anything, my lord.
Where is the additional AG? Please call him.
Yes, Lordship.
Call him. We are waiting for the matter to be heard. This is a parted matter.
Yes, Lordship.
He has to give priority to parted matters.
Yes, yeah, ma'am.
He's on
I'll say it here.
14 constitution.
Item WBC digital. Item RO WBC. Then lordship will see, my lord.
Where is the order of the authorities?
Impugn, my lord, lordship will see. No, my lord, we have not been given anything, my lord. What is the outcome of the subsequent, my lord? That's why your lordship was pleased to ask me, my lord, to see the record.
Have you seen it?
Yes, I have seen
What
it.
have you got?
But there, my lord, we cannot make out anything, my lord. I have noted down, my lord. The percentage, the parameter, how it has come is very difficult to understand, my lord. And in my affidavit also, during pendency of the writ petition, my lord, lordship kindly take up my page, my lord, 134. That is additional affidavit filed by us, my lord, during pendency of the writ petition, my lord. 134.
134.
My lord, it is a continuation of my writ petition.
Yes.
There, my lord, lordship will see the date, my lord. My name have been and date also. It 10/7/24. I have been examined again, my lord, because I cannot hear. Some medicine have been provided and they have conducted some test on me, my lord. But it is very difficult to understand, my lord. And I have been provided certificate also, my lord. Next, page 138. And how they came to the conclusion of 18%, 25%, that is very difficult to assess or to understand, my lord. The language is 135, my lord, cross mark, the original to dear.
Yes.
Then, my lord, they have been provided page 135, my lord. Some graph, my lord, have been, and it is very difficult some to understand, my lord. So my prayer at this stage, my lord, let a board reconstituted comprising of 3%, my lord, other than medical college. Let there be medical college with social welfare department, my lord, because they are the competent
No,
authorities
first
for
we'll have to hold that these findings are incorrect or not clear.
not clear.
Only
So,
then we can direct.
my lord, this finding.
Where is your
original-
affidavit here?
Original copies with me, my lord. Lordship, kindly have a look, my lord.
No,
Very
no,
difficult to
no.
understand.
We are,
Oh, I have
we are,
annexed.
we are with you at page 135.
Yes, my lord.
Where is the affidavit?
If in one case, Lordship, we have filed, Lordship, not in every case, Lordship.
What is that case? Give us.
Lordship,
Case
item number
number.
26. Lordship.
Item 26.
Naam Diba, writ petition number.
2301 Lordship of 2024.
Otherwise, affidavit is needed, my lord. In my each and every cases, my lord, I have annexed some document of orders of some other court, my lord, where it has been held that medical board cannot recommend, my lord. And what is the basis, what is the parameter they have adopted, it is not clear, my lord. Until and unless affidavit, particularly in my case, are being furnished.
What affidavit filed by whom?
Lordship, this was filed by the Lordship. Lordship, by the Principal Secretary, Personnel Department. Lordship.
This is, we are concerned with the health department.
Yes, ma'am. My advertisement will see, my lord, special recruitment, my lord. It's very polite. Filed by the by theater लिखी दिया ना जे आई बाबू
What about the earlier records which were on the basis of which they were given the certificates? Are these records available to the medical authorities?
Lordship, on the last.
Where will these records be?
Lordship, from the Joint Director of Kamrup Metro, Lordship, we have got some records, Lordship, on the last occasion, Lordship. And Lordship, these were based on the 2014 Lordship assessment. But that 2014 assessment reports were not been furnished to us on the last date, Lordship. But subsequently, Lordship, they have given the report that this was based on an entry made in the Lordship, the report book, Lordship, where they keep an entry that this person has been found out to be 40% or 30%. So based on that, they have issued.
So what you are saying is that there was no evaluation.
There was one evaluation in the year 2014, but that they have not furnished us, Lordship, till date, Lordship. The Joint Director in one of the.
Why are you not procuring these records?
We'll get this record.
Who is the Joint Director who has not given you the records in spite of court's order?
Lordship, he has furnished us certain documents, Lordship, but not the 2014 records. He wants some time, Lordship, get the records of
So
2014.
certificate किती है this?
Your evaluation
Was based on, Lordship.
we
the
do not
OM.
understand. Your evaluation, what is there in the writ petition, we don't understand. We are not medical people. We want a certificate from the medical board that the evaluation which was done properly. But in spite of that, because of the nature of the disability, the progressive, where the changes now notice, detailed report.
Jikno case to swap.
But that you can only do when you have the access to the records on the reports on the basis of which the certificates were issued.
Yes, Lordship, the initial.
So you as a department, you are expressing helplessness that your officers are not giving you the records.
This is of 2014, Lordship. So they are seeking some time, Lordship. Lordship, immediately after vacation, Lordship, I can file, Lordship, a detailed affidavit in few of the cases, Lordship, bringing those reports, Lordship, based on which the certificate was issued, Lordship. Unique
Next is
disability
the
certificate.
interview resort. To get your DC.
You tell us which matters you want to file.
My lord.
As on date, you do not know which, relating to which matter the records are or are not available.
Lordship, the initial report, Lordship, yes, Lordship, but the reassessment report, Lordship, we have, Lordship.
Reassessment reports are there.
Yes, Lordship.
We
but
want to know
the certificate.
from the basis of these reassessment reports, fair perusal, at least this court is not in a position to decide why the disability has been found to be below the benchmark level.
Yes, Lordship.
So it is known only to the medical professional.
Yes, Lordship.
Now, on what basis the earlier certificate was issued? It was incumbent on the department while doing the reassessment to call for the earlier records to find out.
Joint directors have issued, Lordship, so Lordship, I'll have to get it from those people, Lordship.
Lordship will clarify, I'll clarify the point, my lord. Lordship, can you take up my page, first writ petition, page 31, my lord? Here, my lord, certificate was issued 45% and it was been signed by page 32.
What about the medical records? Do you have copies of those records with you?
No, my lord, we cannot have it.
You do not have.
Apart from that, my lord, 33, my lord, Lordship will see, my lord, after case also, my lord, they have been issued a certificate, unique identification certificate, page 33. And 31 is, my lord, by the Joint Director Medical. So there must be having, my lord,
This is
must be having with the Joint Director,
Nalbari.
no, any district,
Yes, Lordship.
medical board, and they have also, my lord, Social Welfare Department also, my lord, may have.
How will social welfare have medical reports?
Because, my lord,
They will have your certificates.
yes, yes,
Not the medical records.
not medical. Medical is with them.
Then
After them, my lord,
you have been furnished with these records, which you say you are challenging it. Say page 116. Yes, 116, 118. These are some medical records.
my lord,
You have enclosed it.
my lord.
Now,
I have
at the
done it
time-
personally, 23.
at the time when page number 31 was issued, you want to say no medical records are given.
That also given, my lord, at this moment, I do not have that instruction. Something must be having, my lord.
Must be.
Must be, my lord, because without this, my lord, they cannot give certificate without testing. And lordship will see is a signed by Chairman District Standing Medical Board. Come Joint Director Health Service. Every district, my lord, there must be. They are the one, my lord, who is the custodian of all necessary documents.
In your matter, you are only challenging you are seeking a re-evaluation
My lord.
in all these matters.
In all the matters, my lord, if it is done, my lord, my problem will be over. If it is comprising of board, my lord. Because once issued, they cannot say, my lord. In whole, all the 11 matters, my lord,
Yes.
6 matters.
That can be done.
It would be the Amar case.
And GMC.
I'm supplying, my lord, about my disability in respect of the petitions. To DD. Item ইয়াতে আছে লিখি লোৱা তুমি 11, 12, 13, 14, 15, 24.
Right, heard Mr. J.I. Borvoya, learned counsel for the petitioner, and Mr. D. Upamanu appearing for the respondent health department. And Chief Secretary,
For the Social Justice Department.
MS Chakravarti. P. Chakravarti appears for the Department of Social Justice. Who's for the Chief Secretary? Mr.
Additional energy was appearing, so he could have appeared for all.
Uh-huh.
Actually, additional energy was appearing. So
Your additional age is missing in action. So Mr. C.K.S. Barua appears for the Chief Secretary. And anyone for Guwahati University? Your name? Mr. So-and-so appears for Guwahati University. The writ petitioners claim to be persons with benchmark disability in hearing, visual, and locomotor disabilities. Stop. The petitioners don't use the word disability, say differently abled persons having holding unique disability identity issued by the Government of India. Stop. The petitioners presented their candidature in response to an advertisement dated 30/12/2018 for filling up different posts of grade 3 and grade 4. Stop. This recruitment drive was a special recruitment for, where is the advertisement?
It's my lord. At page 34. 30 December 2008.
Page number?
34.
Advertisement dated 30th December 2018, which is a recruitment for different posts of grade 3, grade 4 reserved for persons with disabilities of different departments under the Government of Assam. Stop. The petitioners were provisionally selected and were subjected to medical examination. Stop. When the petitioners presented themselves before the authorities concerned, medical authorities, they were rejected by the medical authorities upon due examination on the ground that their disability is below the benchmark disability of 40.
45.
Huh? 40 or 45? 40%. Being aggrieved, the present writ petition has been filed. Notices in the matter was issued as far back as on so-and-so date to Sarivam. However, no affidavit has been filed. You have not filed any affidavit, or you have filed? No affidavits. No affidavits have been filed. So, the limited grievance of the limited prayer in the writ petition is for interference of the disqualification order, setting aside of the disqualification order dated so-and-so, and for re-evaluation and for re-evaluation by an independent medical board. Stop. Better. During the course of the hearing, the counsel representing the state submitted that if there is a direction from the court, then as per the direction, a special medical board will be reconstituted for re-evaluation of these writ petitioners, and thereafter, if necessary, evaluation will be undertaken and the particulars will be furnished to the persons concerned as well as before the court. Correct. We are disposing of the matters.
Lordship, only one thing, my lord, the board to be constituted other than the person who examined already mine, other than those two persons.
Why?
Because my lord, my document says one thing, pendency of the
No,
case.
we will decide that. It is for them to decide. Unless you are making allegations of malice against these people, then
Lordship, I am living up to Lordship, my lord, I should get justice, my lord, that much.
yes, Mr. Gogoi, we are disposing it off with a direction to set up a special medical board.
Lordship will direct the, my lord, principal come chief superintendent GMCS to personally, my lord,
But this direction will be with a rider. You will have to get the earlier records pertaining to each of these candidates,
Lordship.
on the basis of which the disability certificate was issued
From the districts.
from the districts. And if these records are not available, then a special remark has to be given by the
Lordship.
medical board.
Lordship.
So, the counsel for the petitioner does not oppose the no, the counsel for the respondent does not oppose the prayer made by the writ petitioner. So, considering these submissions, since this is the prayer made before the court that a fresh medical evaluation is called for by an independent medical board, this court is of the view that in the absence of any affidavits being filed by the respondents, and in the absence of any particulars and materials placed before the court by the petitioners also, as to whether as to the basis on which the writ petitioners were granted the certificates of benchmark disability by the authorities prescribed in their respective districts, this court is of the view that ends of justice will suffice if the writ petitions are disposed of with a direction to the principal
Chief superintendent, GMCS.
Superintendent
GMCS.
to constitute a medical board comprising of specialists, comprising of specialists who would be competent, who would be considered competent to examine the petitioners who claim to be specially abled who claim to be specially abled persons and who claim to hold the benchmark disability certificates issued by the district authorities, prescribed district authorities. Stop. The principal chief superintendent GMCH will be personally present in each of these in the committee constituted, and will be at liberty to include members who, according to the principal chief superintendent, would be a competent authority to determine the degree of disability in respect of the writ petitioner's stop. it is also to be noted that in respect of each of these petitioners, the records, medical records on the basis of which the earlier disability certificates were issued by the competent authority should be called for and examined. And thereafter, the evaluation is to be done and appropriate certificates as to whether or not they fall within the benchmark disability are to be issued individually to each of these petitioners. Stop. In the event, the medical records in respect of any or all of these petitioners on the basis of which the earlier disability certificate, benchmark disability certificates were issued by the district authorities are not available, then a specific remark to that is that aspect should also be made in the certificates that are to be issued as directed. Stop. The petitioners as well as the respondents will serve copies of these certified copies of this order to the principal cum chief superintendent GMCH, and within 10 days thereafter, the said authority will constitute the medical board as directed, and the petitioners will be personally intimated through telephone, email, etc., to be present on the dates when the examinations are to be conducted. Writ petition therefore closed in terms of the above.
And my lord, one more thing, my lord, there is some interim order in item number 24, my lord, and after examination, my lord, consequential action will follow.
After examination, if the petitioners are found to be
Eligible.
within the benchmark disability, then consequential orders in respect of their selection to the posts which they had applied for pursuant to so and so advertisement will be issued by the respective department.
My lord,
Copies
the
of these, copies of the evaluation reports should also be furnished to which department? Social justice. Social justice. Social justice and empowerment department. Government.
my lord, till the decision is being taken or examined, my lord, no post shall be filled up, my lord.
Interim should continue.
Whatever interim order.
Interim is only item number 24.
Yes, that will continue.
And all the cases notice was issued for interim relief.
Is it
Except-
filled up, not filled up? We do not know what is the position.
At least, my lord, my interim there is in
If the
item number
if the posts to which, if the posts in which petitioners are offering their candidatures have not been filled up, the same shall not be filled up by the respondent authorities till the evaluation, medical
My-
evaluation
my
is
lord.
directed, is concluded.
And interim
more
order
line,
is
my lord.
March, my lord, in item
Yeah,
number
obviously
24.
March, yes.
Well, one more line, the joint directors, concerned joint directors, who have issued those certificates, they will provide them, promptly provide the reports to the committee.
The,
One line, my lord.
the
In
the
between.
joint directors, the competent authorities in the districts, namely the joint directors, who had issued the disability certificates to the petitioners, shall ensure that the medical records of each of these writ petitioners are furnished and placed before the committee as directed to be constituted within the time frame as sought for by the principal cum chief superintendent, Guwahati Medical College. Dispose.
Dispose of money. I have given
Which
my-
are the item numbers?
I have given, my lord, I have supplied to your lordship.
No, no, no.
12, 13, 15.
The costly is the amount.
What is the, what are the, okay, 11, 12, 13, 14, 15 and 24?
Yes.
Disposed of.
24 is mine, my lord.
Huh?
My number is, my lord,
This order.
11 to 15 and 24
Yes.
disposed of.
Well, in respect of my items also, my lord, this order will cover, my lord.
Your matter, your item also.
Item number 10, 16, 18, 20, 21 and 22.
Give it to me in writing.
Yes, my lord.
My lord, in item number 17, 19 and 23 of similar order.
You give a list.
Yes, my lord,
This is ready, my lord.
Ah.
In fact, in my, all these items, my lord, there was an interim order, my lord.
in 17, 19 and 23 also interim orders there.
এইকেইটাও লৈ ল'বা, disposed of, similar orders. So these matters are also disposed of in the same line. And
Interim orders are there.
তলৰ কেইটাৰ interim order আছে. Interim orders wherever passed will continue till such orders are passed by the committee directly to be constituted.
Obliged, Lordship.
Yes.
No, I apologize, my lord. I had to leave in between, my lord. There is a infrastructure bench, my lord, specially constituted at.
No. We know about all these difficulties, but what to?
I understand, my lord.
The
No,
court has
suddenly,
to-
actually, my
the
lord,
partner matters we have to hear. You have to settle responsibilities on your colleagues.
I gave him. No, actually, I was supposed to inform the court, my lord. Suddenly, my lord, after rising of the division bench, that bench came, my lord. Was constituted.
Your colleagues must realize that when they are in a battlefield,
Yes, yes.
they are on their own.
Lordship.
So your apologies are not necessary. Your colleagues must be able to live up.
Lordship.
My lord,
So
The other cases, my lord.
other matters, he has given a list. You go through the judgments
Lordship.
and you apprise the court on the next date which is fixed.
After Bihu, my lord.
27th of January.
My lord.
my lord. On-
27th, you tell us how the judgments are relevant. Have you been served with a copy of the list?
Yes, I have
You have given him?
Yes, yes.
Send it by email. Send it by email.
My lord, yes, we will have it now.
27th of January.
And my lord, especially my lord, I invoke the doctrine of indirect discrimination, Lieutenant Colonel Nitisha.
We are not hearing the matter now. We'll hear it on 27th. You serve the judgments. Yes.
Obliged.
Item 47.
Yes.
But matter relates to compulsory retirement of an employee, my lord. In the meantime, pleadings are complete.
This is for hearing or admission?
My lord, it's for admission. I would request this honorable court to let it be for a admission hearing, my lord.
Right, you take a date.
My lord,
February?
immediately after vacation or
Immediately after vacation.
After Bihu, your lordship.
that can be also done, my lord.
So come in February. February.
My lord, is it possible? Is it possible January 29th?
27th of January. We'll have it on 3rd of February.
We can, ma'am.
3rd February.
Or 29th January, if it is feasible, ma'am.
29th, 84 matters are fixed.
Okay, ma'am. Then 3rd of February.
3rd of February. As agreed to by council for parties, matter be listed for admission hearing on 3rd of February.
Obliged.
My lord, only I think there was a order in the month of June for the records to be produced at the time of hearing.
We have received it.
Okay.
Department, the records relevant for the present proceedings, we kept available for perusal of the court if the need so arises.
Obliged.
Deeply obliged.
48.
May I please, Your Lordship? Lordship, the matter pertains to Lordship correction of date of birth, which was subsequently altered, Lordship. The main issue has already been decided by this honorable court, Lordship. And followed by that order, court's order, Lordship, the order, speaking order has been issued by the respondent authorities, Lordship, and challenging that order, Lordship, this petition has been filed, Lordship.
Readings are exchanged.
My lord, we are yet to file our affidavit, my lord. We have received some instruction, but this instruction, my lord, I may need some more instructions. So,
Mr. H. Talukdar for the writ petitioner, MS P. Chakraborty appearing for Hima Hasao.
yes, madam.
Hima Hasao. She submits that further instructions are necessary for her instructions are not complete. She prays for further time. Let the matter be listed again after 3 weeks. Yes.
But last order, my lord, they were given as last opportunity, my lord.
Last?
11/2025.
Huh?
6/11/2025.
Yes.
They were given the last opportunity to produce the records.
Wait, please, your lordship.
Regarding the inquiry process. My
Yes.
case is that after submission of the, my lord, so-called reply, I was never, my lord, invited to participate in the process. Everything was done behind my back. Nor even the inquiry report was submitted.
It was conducted by whom? Inquiry by whom?
Inquiry by the deputy commissioners, district commissioner. I did not know even who will be the.
Inquiry conductor, inquiry officer is lordship, District Development Commissioner Sibsagar.
You come to your affidavit filed by the district commissioner.
Yes, lordship.
Come to para 6 and para 10.
Yes.
Para 6 and para 10.
Yes, lordship.
You say that he has knowledge of his dates. On what
Because
basis?
that he has filed a so-called reply against our so-called notice.
Hmm.
Second thing is that charges was been well communicated to him. But only thing is that the hearing of the DP took place in his absence.
Hmm.
So in that regard, lordship, on the last day, lordship, I have submitted that let me get the copies of the notice, because before the hearing notice
That's what we wanted to
lordship,
ask you.
that we have written to the DC lordship
Huh.
that copies of the
What
notice. If
copies you call for the records? What copies?
no record, I already have.
Then if it is not there, it is not there. If the disciplinary proceeding records do not contain any notice, from where will you get the record, copies of these notices?
Even then, lordship, I tried to inquire with the parties, lordship, whether if they can only that thing, lordship, whether any
It
notice
is not there. What?
no
is the
notice. I have gone through the record, lordship.
There is
No
nothing
notice,
there.
yeah, no notice before the hearing is not here.
Then it's the end of the matter. What about appeals? Have you filed any appeal?
Appeal file.
Appeal also dismissed. Where is your appeal? Where is your appeal memo?
Page 64.
64. Totally appeal হৈছিল নেকি? Disposal আছিল যে? হা? কিমান নম্বৰ আছিল? Disciplinary, হা? আপুনি লৈছে? Same line লৈছে. Mr. Hendik, anything to submit?
We already file our affidavit by the as per number 3 also.
No, but if notices are, if the proceeding is gone,
The notices have been issued to the witnesses, and those I have annexed at page 57 onwards.
you have been given inquiry officer report. Nothing.
Nothing.
How did you file the appeal?
No, without the inquiry, report. Only order was communicated. In this petition also, I am not enclosing the inquiry report. I don't have that.
Where is the order of the
Page 63, my lord, dismissal order at page 63.
63.
And the ground assigns are also not covered by, my lord, rule 311. And
Yes, Mr. Borua.
So one
No
of
inquiry report, no notice. What kind of proceedings are you conducting?
Lordship, that's all. Lordship. I'm also taking up the issue with the parties, Lordship, because if they
Even
cannot.
if you take up, if it is not there, it is not there. From where will they give you this? You have got the
No,
file.
Lordship, one thing, Lordship, in fact, on the last date, the record that they have provided, these are all photostat copies, Lordship, except 2 or 3 documents, Lordship. So. And also, in every record, on the left-hand side, they maintain a office note. The office note is also not here. Accordingly, Lordship.
So what with this, my lord? After submission of the, my lord, reply.
All right, you get your information, we'll take it up on Wednesday.
Yes, it's one opportunity maybe.
Wednesday. On Wednesday, you inform the court whether these documents are available or not.
Lordship.
And if the instructions are not furnished to you by the officer, you inform us. We
Definitely.
pass orders.
Definitely.
And the request made by Mr. CKS Borua, Learned Counsel appearing for the state, the matter stands deferred to be listed on Wednesday, 17th. To Mr. Borua has sought the adjournment to complete his instructions from the respondents as to whether the to complete his instructions with regard to the records of the department, which according to the Learned Counsel, which although received are not complete. Let these instructions be placed before the court on the next date fixed 17th. Attempt will be made to dispose of the matter on the said date. Mr. P.J. Soikia, Senior Counsel, assisted by Mr. P. Bodoloi, appears for the petitioner. Mr. J. Hendick for Revenue Department and MS. Are you there, Ms. Chakraborty? Yes. Yes, Mr. Das.
After vacation করবেন কি? After vacation করবেন?
My lord, this matter, they have filed an affidavit. There is an order which is passed by this court protecting us. My very narrow campus, the matter is off, my lord.
Pleadings are complete.
I'm sorry, my lord.
Pleadings complete.
Yes, pleading is complete. If your lordship just look into, we want that the matter should go back to the authority concerned for re-verification. But that process has not been carried out as per the order of this court. That's what we want, my lord. My lord, if your lordship kindly see the second round of litigation from 530 page and kindly see the order that has been passed by this court at page 534, it starts 534. Lordship got it?
No,
534.
What is the matter about?
Yes, sir, my lord, this matter, there is an OM
Ah.
which has been issued by the government, my lord.
Ah.
That OM said that if you have worked more than 5 years, from 1/4/1993 to 24/1/2001, if you are covered by that, so your services will be retained by the government. Now we fall under that. Now that was not considered. That second round of litigation we came up before this court. That exercise was not carried. If you see at 534, my lord, kindly see 534. 534, my lord.
It is the case, my lord, can you see? 534. It is a case of the petitioner. They were engaged as master role worker in different division of water resource department after 1/4/1993, and they have completed 5 years of contested working as various division of water resources till 24/1/2001. Now, the matter was taken up. It was heard on. Now, my lord will kindly see at page 536. 536, my lord. 536, Lord, you got it? 536. Mr. R.M. Das, the understanding of Water Resource Department, is unable to clarify before this court as to whether any exercise has been taken by Water Resource Department for verification of master role workers, work charge sectional assistant who were appointed after 1/4/1993 and have completed 5 years of service up to 24/1/2001. After the order dated 4/5/2010 was passed in WPC 560/2009. RM does the understanding of water resource also submit if the matter is remanded back to respondent for re-verification. There may be some chances of misrepresentation on the part of the official. As this court has already observed, report annexed with the additional affidavits of year 2008, this court is of considered opinion that without entering into merit of the case, it would be interest of justice to dispose of all the writ petition by directing the respondent authority in the Water Resource Department to have a re-verification with regard to a claim of the petitioner as to whether they were appointed after 1/4/1993 and have continuously been serving for 5 years till 24/1/2001. Let such exercise be done and completed within a period of 6 months from date of receipt of the certified copy of the order, and thereafter on completion of the exercise, the petitioner shall be intimated with regard to the outcome of such verification. Now, they doesn't do the verification. Apparently, there is an affidavit which has been filed by the water resources. What they have done, my lord, kindly see the impugn order at 550. See 550, my lord.
Yes.
This is a minutes of meeting on 6/9/2024. Now, during the course of examination, the documents were received from the various division of department were carefully examined and verified. Upon verification of document were found to be not genuine, and hence it cannot be admitted by department. It has come to a notice of members present a meeting. Most of the candidates who have attended the office of the concerned executive engineer of various divisions failed to produce any relevant document in regard to their appointment. Moreover, some of the candidates produced some document, but the same were doubtful. Record of the same document not available in concerned division, as well in office of Chief Engineering Water Resource. As a result of which it unanimously decided by committee to hand over the said case of the person pertaining to aforementioned cases, along with the documents submitted by them to the Criminal Investigation Department of Assam Police for further investigation, and also resolve the issue, and also to take legal action. Why? As they deem fit and proper by them. Now, this matter was moved against this order. Kindly see the order passed by this court on 22/1/2025. Kindly see that order, my lord.
No, but the verification, there is a reference of some examination.
No done. Is now apparently they have committed affidavit. Please see when the verification was done by them. Please see, my lord, at page 560. Affidavit in opposition, C 560. Filed by Water Resources. Now kindly see what is the date? 9/5/2025. This report was furnished. How authority with the minus of can take a decision on 6/9/2024? That means that is why if your lordship sees at 550, date of verification also not given. Various division of department documents were received. There was no verification done.
No. Kindly, this is a report submitted by the executive engineer.
When, my lord? And this is which date, my lord? 9/5/2025.
9/5 is the report, but see the contents.
No. My report is on 9/5/2025.
No. Kindly see the contents.
No, they made a clarification subsequently. which when we file a reply to this, my lord, our stand is that there is no verification has been done. How can you, this is a report, your lordship is right, of 9/5/2025. I think I am not very clear to your lordship, my lord.
No, no, you are clear, but what we want to understand is that what you are saying is this report is submitted on 9/5.
Yes.
But the report indicates that some verification was taken pursuant to advertisement dated so and so date.
No, no.
5th of June.
My lords, when verification? This, they said in Assam Tribune, so a verification team notified. But my lord, there has to be some verification prior to the order that has been passed. The order was passed on 6/9/2024. Now they realize, my lord, they realize why I'm saying we file an affidavit reply against that. Now they, what they have done, kindly see, very interesting. Please see their affidavit, what this additional affidavit. Para 3, kindly see, my lord.
Yes.
Yes. 591, kindly see. These are serious matter and they cannot say all this 591. That the deponent begs to state that as stated by petition in paragraph number 5 of the reply affidavit, deponent like to clarify date as mentioned in the affidavit in opposition in the month of
May 25 means this 9/5.
Yes.
9/5 is by inadvertence.
They said, and not only one, there are other reports, all the reports. When we come up and we file a reply to their affidavit and say, when we say that this is the what you have tried to project, that means there was no verification. 9/5/2024 order of 6/9. Now they come up with this and see what their self-declaration at page 595. All the self-declaration.
What is this, madam?
They come.
Actually, my lord, I would require some time to go through this, my lord, because I am newly interested with the brief, and there are some records also we have received. So,
No, the question is whether prior to the impugned order at 550, whether any verification was at all done.
That
And
there
if so, what was the report of the verification?
the executive engineers have said in this affidavit, additional affidavit, that it was inadvertently that date was mentioned as.
We are tempted to issue notice to him and issue an order for instituting appropriate proceedings. How can it be inadvertent, the date? Number one. Then he has referred nothing at page 560 with regard to the number of this order. You see the number at 560? Number of the communication? The communication is dated 62. You check up this file and tell us whether it is 9/5/25. When was this order issued?
And I could have understood that one executive engineer would have done a mistake. All 11 executive engineers, we will do the same mistake on different dates. All different district, my lord. It was 62. 2023. So what is the number? 2023 number. What we are, my lord?
Mr. D. Das, Learned Senior Counsel, assisted by K. Mohammed and MS so appearing for the petitioners, and MS K. Chakraborty, P. Chakraborty, Learned Standing Counsel, Water Resources. Although pleadings are complete, Learned Counsel representing Water Resources Department submits that she's been recently entrusted with the matter and she would like to apprise herself with the records of the case. Therefore, she prays for 2 weeks' time. Matter therefore stands deferred on a request to be listed again after 2 weeks.
Any date, if it's not inconvenient.
19th January,
January, my.
19th.
I think that can be on seventh, somewhere 7th and 8th of. January.
7th, all right.
7th of January, man.
7 January.
There is an interim order which will continue.
Interim
Water
order
is
passed
protected
early
us.
will continue till the next evenings.
Your lordship, reading is complete. I have to go through some judicial pronouncement.
Yes.
Let it come after vacation.
Lordship. It is submitted at the bar that the pleadings in this matter have been exchanged. Matter is ready for hearing. List this matter for hearing in the month of February.
February.
Yes. Mr. R. Mazumdar for petitioner, Mr. J.P. Goswami for the state.
No, the Standing Council Animal Husbandry.
Standing Council.
Animal Husbandry and Veterinary Department.
Veterinary. All right.
On hearing item 52.
Let's say, can be taken some other Mr. Borpuzar is there, my lord, he's less in some other court, lordship. And also lordship was asked to, my lord, they have obtained some instruction, it is waited. Next week I can.
Monday.
Lordship, 2015 matter.
Monday.
pension matter, Monday. Monday কি বাকি? হ্যাঁ? আছে? হ্যাঁ?
This matter.
Monday কি বাকি?
Monday or
Deferred.
Tuesday.
The request made
Tuesday
on
কি
behalf of Mr. R. Borpuzar,
If you want on Tuesday.
learned counsel appearing for the revenue.
Revenue department.
Department,
Well, he was, he appeared on behalf of the finance.
Finance Department.
On 10th, my lord.
Huh?
10th?
No, 10th. কি মাস? 20 কি মাস? First week. January first week. হ্যাঁ?
We are thinking of disposing it of next week.
Next week, all right. On 10th, my lord.
10th?
10th.
I think you're 11th.
18th.
Not 18th. How can it be 18th?
Then we have, after the
Pick a date
vacation, we'll do
on
that.
16th or 17th.
16th?
Oh,
List on 16th.
16th.